Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not proven.
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for his verbal slappies.
Is that correct?
That's literally not true.
I didn't ask you to interrupt me. Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. This sounds like exercise music, which makes me think I've done my exercise for the day after I listen to it. But it's not helping my diet at all. It is wonderful to have you all here. We are so excited for what is coming today. Finally, we'll be going to our familiar courtroom for the wrap-up for the final hearing in this trial, the sentencing of Brian Walshe. That's going to happen a little bit later. We do have some birthdays today. Greeters. Thank you, Jan. Thanks for the kind words. Paula Mack. Chat on screen. There we go. Paula Mack first in chat today. Congratulations. It might have been an accident, but we're counting it as on purpose. Your punctuality this morning and your propensity to chat means that you're a little eager for the day. You're just a little too much energy. Okay, you know what I mean. It's early, and here you are going. See, I'm here. Yes, we see you're here, and we're going to punish you for your promptness and your punctuality. We're going to send it to you to internet ownership. Everything IP related worldwide is your responsibility, at least until we go live again, probably this afternoon. I say probably because I might have to be driving to the airport to pick up my son later this afternoon. But we're talking, I have to leave by 3-ish. So we'll see. We'll see what happens. We'll definitely get through things tonight. Or this afternoon. Let's see. I mailed you a package last week. It arrived in North Carolina on the 13th, but then decided to go for a joyride to Chicago, the Windy City. Maybe it went to Mike. I'll talk with Mike. I will keep tracking it and let you know when it arrives. Classic Rock. Love it when our packages just go, on side trips. We bought a couple years ago. We went all out and we decided we were going to buy our kids one of those. I don't know, it's like a 12-in-1 foosball, air hockey, ping pong. It's like every game in one that can be played on a table. It was that, and we bought it on Amazon, and it still hasn't arrived. They say we got it, but it never arrived. We would have known because it's the size of a car. And they said, no, it arrived. We show it arrived. And I said, do you have any proof of delivery? I'm like, we checked the proof of delivery. It arrived somewhere else. So we're going to credit you back. But the person where it arrived, I believe, kept it. So there's that. Josh says, happy birthday to Babs, Ginger Ale, Helen Handbasket, Iris, James, Peter. Is it Peter Ware? It's Peter Ware. And Sarah T-Rex. 1, 2, 3, 4, 5, 6, and 7. That's 7 people to sing to. We have to do that before court starts. So let's do this now. Everyone, wherever you are, stand up, take a breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That music's really loud. Happy birthday to you. Happy birthday to you. Happy birthday, dear Babs, Ginger Ale, Helena Handbasket, Iris, Julian, Peter Ware, and Sarah T-Rex. Happy birthday to you. Okay, that was really crowded. Babs, Ginger Ale, Helena Handbasket, Iris, James, Peter Ware, and Sarah T-Rex. Happy birthday. Please accept my poor attempt at cramming all your names into one verse as, in fact, me singing happy birthday to you. because I did get most of the syllables in there. Sarah T-Rex, 32 years young today. Wow. Congratulations. Oh, to be a kid again, right? Oh, to be a kid. Happy birthday to all those who are celebrating their birthday. I realize there are many wonderful days. Today is your special day. And I realize there are a million places you could have been and a million people you could have celebrated with, but no, you chose to be here with us. And that privilege, the pleasure, the joy we feel of you celebrating your birthday here with us, we want to return back to you, make your day just a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. The birthday song comes with a disclaimer today. Apologies if we missed your birthday shout out. The birthday form is checked multiple times before the song du jour, but we're not responsible for late ads for the day of the song. And we're not responsible if we miss one. Josh said, I told you to do 2 verses. I told you. Passive-aggressive birthday disclaimer. Tammy says, help yourself to the pancakes. They're hot and ready. Thank you, Tim. Thank you. Only vodka tells me I can sing, but humming along anyway. Nice, Miss B. That is great. Drum solo for the finish. There we go. Now Red Pen can end the heart attack portion of the show. And we can proceed on to the case at hand, which today is the Brian Walshe sentencing. This is the one we've been waiting for. It was supposed to happen yesterday, but then at the last minute it didn't. It may have been an issue with pre-sentence investigation, the PSI stuff. It may have been an issue with coordinating some of the victim impact statements. But either way, we've made it here. We've got a few minutes before it happens. Paul Max says, internet ownership and it's my day off. What could possibly go wrong? Today I finished replacing my wallet, driver's license, and bank today. Nice. I have to order water. Or, Deer Park, it would be a great time to finally come through with that sponsorship and just send me some water. That would be great. Deer Park, where you at? Where's my Deer Park peeps at? I'm down to my last, and this is like a sort of squished bottle. So I think it's like a few drops shy of a full bottle. Actually, I have 2, but that one's warm. This is cold. Carol in Florida, I might add, says, your happy personality rubs off on me. How is Florida? I was just online on the interwebs looking at X, as a matter of fact, looking at all the tweets, because X can change the name, but it will still be a tweet to me. Ryan Hollyall just posted. He's like, just a little FYI, guys. I'm using Wyoming. I already know this. Little FYI. We just had a recorded wind gust of 144 miles per hour in Wyoming. That's fast. That's like a Category 4 hurricane in a wind gust. High elevation cabins are gone now. It's crazy. That is so fast. Kim R, is anyone else having problems with YouTube not letting you comment when subscriber-only mode is turned on, even though you're a subscriber? We saw that yesterday. We saw that problem, and it reared its ugly head. Apparently, it has not been fixed by the devs quite yet. What is the party? Oh, Greeners is throwing a party for the wind, I think. I didn't know the party sound was activated. Greeners, good way to find that. Tammy says, I'm having me some Stevens hot chocolate. You cannot go wrong with Stevens hot chocolate. I'm sorry. There are many types of hot chocolate. Swiss Miss, love you. It's great. Not the same. Nesquik, good, but you sort of need to add Nesquik to milk, not to hot water. Stevens Gourmet Hot Chocolate. Now is the time to give a plug. Let's do a proper plug with a affiliate link and everything. Hang on. We will do this from scratch.
Squirrel.
I will tell you, I bought I bought 2 4-pound canisters of Stevens Gourmet hot chocolate because it is that good. And I did this. Where's the? There's a pack of 3. What is the party for? Who is doing this? Somebody is throwing a party. Sherry Smith, member for 27 months, still here and loving every minute. Sherry, you are an OG. Thank you very much. Red Pen's doing the party. Okay, I was telling you I bought
In front of the Walmart.
what is the? Did I miss? Is there something I'm supposed to be celebrating that we aren't?
I'm trying to have court. You don't raise your voice again.
American hot chocolate is horrible. My choice is Hotel Chocolat here in UK. Okay, Jan, but that's because you don't have Stevens Gourmet hot cocoa.
Happy birthday. You look good.
Let me find the link that where's the pack of 1? Okay. This is just the brand, okay? Look. Get link. Copy.
Somebody just sent me a video of roaches fighting. I don't know who won.
Thank you, sir.
Just posted the affiliate link for the Stevens Gourmet hot chocolate. I would recommend, just really quick, I would recommend you don't buy it on Amazon. I know I just posted an Amazon affiliate link. If you did buy it, I would make some money. But listen, hear me out on this one. Don't buy it on Amazon.
I saw a chicken fight.
I just
Don't
bought
put a diplomatic plate on a hoopty.
a 4-pound can of Stevens hot chocolate mix from Sam's Club. I actually bought 2 of them, and I think I paid less than $20 each for the 4-pound cans. And here, it's just too expensive. Sam's Club has it. Sam's Club has it, and it's cheap. And if you don't have it at your store, which is fine, they can either ship it to your store or they can ship it to your house. And so I recommend you find the brand, click on the link, buy your other stuff from Amazon, but buy this at Sam's Club. It's the way to go. Anyway, especially to get through these cold winter months. It's fabulous. Lunchtime already, S-Bar? Wait for it. I wish someone would buy me some Stevens Gourmet hot chocolate. Anyone love me enough to purchase me some? I don't have a Sam's account. Maybe, Josh. We'll see. We'll see. Is this Stevens hot chocolate? Yes, it is so good. Not a sponsor, also. The Christmas present I purchased for my husband has landed in North Carolina, says Pat Hunter.
People do not get to have
RA, you may keep it if it gets delivered to you. Okay. My wife's present arrived. And I think y'all know what it is, right? Did I tell you what her present is? I know she knows what it is because I put 3 of them, 3 versions in the shopping cart, and she removed the 2 she didn't want and clicked order. So I'm not spoiling anything by telling you this. But don't tell her. Don't tell her you know. It's a chair. It's a nice rocker recliner, overstuffed, beautiful chair. And it arrived. And I was expecting it to come in pieces. Apparently, it is fully built. This box, I don't know who had to carry this to our door. I don't know how they got it up our steps. I don't know how my kids got it in the house. But it looks like a love seat, but taller. That's what it looks like. It's massive. And I got my daughter to wrap the entire thing. It was so heavy she needed help flipping the package over as we're trying to wrap it with, like, you have to wrap it 2 directions just to do it. But yeah. Anyway, it's wrapped. It's now sitting in the front room. It dwarfs our Christmas tree. The Christmas tree is sort of hidden behind it. We just can't get to the tree anymore because my wife's gift's in the way. So we have this massive box. I could fit in the box comfortably and live there for an extended period of time. There's just that much room in the box. It's huge. Anyway, shout out to my daughter for wrapping all the gifts that I needed to this year. Can we get a pic of the wrap chair? I'll see if I can put that together. But I have to say, my kids decorated the Christmas tree, and I sort of want to take a picture of that because they decorated the tree. the way they applied the lights on the tree would be something you might expect to see with somebody who used duct tape on a body bag, right? And you know how you wrap the body bag with duct tape, or, you know, in the shows? Hypothetically, people tell me that that's what you do. You understand what I'm talking about. That's how they wrap to the tree with lights. It is bound tight, and it's just... So I have to show you the tree as well, because I think it's great. Like, the branches, you can't fluff them. It's like, it's in the stow position, wrapped with lights. They were inspired by the Halloween decoration. Are we on time? We are on time. The clock is slow. It's losing time every day. So remember, in court it was a couple minutes slow. It's now 5 minutes slow. So there's that. I can check to make sure we're truly on time, but I can tell you we are on time. Okay. Anyway, it's the Christmas tree hostage. It is so good. So I'll take some pictures of that. We need a pic of the tree and a pic of the box. And then the gift that I am getting, which is also a chair, because I get a chair once a year because I break mine. I fall asleep in them. I fall over in them. The chair just breaks. And I don't believe in spending a lot of money on a chair until I'm a judge, which is not going to happen. So I just won't have a nice, expensive chair. Anyway, the chair I got, I thought it was in a big box, but it looks like a little teensy gift compared to my wife's box. Everyone gets a chair. Fall over in the chair. I've not fallen over the chair on a live stream, but I have fallen asleep in the chair and fallen over, which is not fun. Because you wake up halfway down, and it's super confusing. Like, what is happening? Why did someone throw the chair at me? Oh, wait, that was me. Why I'm on the floor? Yeah, it's fun. There'll be 3 bears in the house. We need a little tiny chair as well.
The zombie apocalypse may be upon us.
All right, I have to, Josh, you posted this, and I have to issue a retraction. We can't have a podcast tonight. 2 things. My son is arriving home from the airport, and I sort of have to spend some time with him, and I might have to be there to help him get home, which he'll be home before then, but I miss him. That's what it is. And second, Thomas is working a cattle drive and is beat. I mean, I would ask him for pictures, but he just doesn't have the energy to do it. He's getting up at 4 o'clock in the morning, Texas time, and working all day long, running cattle and vaccine and branding, or I don't know if they brand anymore, tagging, whatever it is they're doing. He's doing all that, and it's not going to work this week, unfortunately. Do we get an affiliate link for the chair? I can look and see which one she got. I don't think you want an affiliate link for this chair. This chair has been broken for about 3 months, and if I balance just right, it doesn't break. But if I lean, it goes crunch back into the left. But I have to sort of put the pin back in to make it stay. You need a cushioned rug for below the chair. I have one, but it doesn't work with the wheels of the chair, so I keep it under my desk. Where did you purchase a recliner from? It came from there's a furniture store that oh man, everyone's heard of it. Amazon. Came from Amazon. Everything we bought for Christmas came from Amazon, except for the gift I got from my wife last night. I was super sneaky. She has no idea it's coming. She has no idea what it is, because I had to drop my kids off. They were going Christmas caroling and giving out cookies at a retirement center nearby for a youth activity. And so I dropped my kids off, and then I headed to Target. I'm sorry, have you ever shopped at Target? I don't shop there very much, and I remember why. Because the line was ridiculous. Like, the line to check out goes all the way past, like, all the front down almost to the, I guess it's like a food section, but it just has, like, very little food, and it's very little selection. It's weird. They have, like, food sections, and they have just shorter food sections, and it was the shorter food section. So the line was incredibly long. So I'm checking out. I got the thing for Mrs. R.A. I happened to buy, also see that Mr. Beast had some Beast jerky on sale that is partnered with Jack Links, and I thought that looks good. Anyway, I'm standing in line forever for the checkouts, and I'm doing the self-checkout. and one comes available, and it's got a big sign that says card only. And I brought cash because that's the only way Mrs. Ari can't find out about what I'm buying, because it's cash. Rare. I think it's the first time I spent cash this year, and so I'm in line, and it comes available. And they're like, "This phone's available." I was like, "Oh no, you can go ahead. I need one of the others because that's card only." So I went to one of the other ones. Apparently, Target, all their self checkouts are card only. And the lady's like, no, these are card only. We don't have any cash. I'm like, so the whole legal tender for all debts, public and private thing, you guys just aren't on board, or what? And she's like, tell you what, come over to customer service, and I'll help you check out. Now, you have to remember that since the last time I was in Target was a long time ago. And between then and now, I've been watching a lot of true crime type shows and seeing security video. And so I walk in there, and I'm like, I wonder how many of these shoppers are actually undercover Target security people. I'm like, well, there's one way to know. I can get their attention. And so I do. I'm like, I go and I walk right up to something and pick it up. Like I'm not even looking at what it is. Like I'm just going somewhere, looking around and grabbing something off the shelf. Have no cart. I've got my Courtroom Confidential black hoodie on, so I'm trying to look as suspicious as possible, right? And I grab it and I just keep it down by my side, and I'm walking around, and I stop at end caps. I make a point of looking up at the cameras. I'm doing everything I can to just try to trigger their response. Of course, I was keeping it legal. Nothing's going in my pockets, and I'm paying for everything. I might get kicked out of Target for saying this, but so sure enough, a guy comes over. He comes down the aisle and he turns and starts shopping, and he's giving me the side eye the whole time. I'm like, okay, so either you think I'm stealing something or you're about to steal something, because both of us look pretty shifty here. And so I'm walking around, and I see him, and I walk around somewhere else, and I see him again. I'm like, yep, busted. I just made him. He's definitely a security dude. So anyway, I got the stuff that I needed, and I'm sure security was going to stop me at any time, but I kept it in plain view the whole time. So I just had it down my sides. I don't recommend doing this, by the way. And so when I go to checkout, and the lady's like, oh, I can help you over here at customer service. I'm like, okay, this is it. This is when the cop jumps out from around the corner and says, sir, can you empty your pockets? But no, I go over there, and there's like a line in customer service as well. Okay. And she walks over to one of the registers, and everyone else in front of me was a lady. I'm sorry, I don't know why it worked like that. I was the only man in line in customer service. And so she walks up there, and she's helping one person answering their question about some package they ordered online, but it didn't arrive, but it's here on the shelf. Can I cancel the online? Just get the one off the shelf. And while she's doing that, she's like, sir, can you step over here? I'm like, yeah, this is it. And she's like, and so I'm like, excuse me, ma'am, excuse me. These people have been standing in line the whole time I've been there. And I'm just pushing past everyone up to the front. She's like, yeah, I can check you out right here. And she rings it up, and I pay her the cash, and I go. And I'm like, I'm so sorry, people. I'm so sorry. I don't know what I did. I can tell you what I did, but don't do what I did to get the service that I got. But there were no police. No one chased me out to the parking lot. I got the gift from Mrs. R.A., and it was all good. So don't wear red when you go to Target. I was wearing my red shirt, the one I wore yesterday, but it was under my hoodie. All right, express services for suspected shoplifters. Yes, I imagine had I not produced the product, which they saw me take off the shelf at that point, I would have been apprehended. But I made it out in record time. Didn't have to wait. All right, we are in the Brian Walshe. I'm sorry, we're focusing on the Brian Walshe sentencing today, which is going to start here any minute now. We're going to hear some hear ye's. There's no jury anymore. The jury has done their job. They've convicted him, found him guilty of all counts. The worst he can get in Massachusetts for this crime is life in prison without parole, and we anticipate that will be the sentence, because I think he was found guilty of capital. It's like a minimum mandatory. The only question is what happens with the add-ons. The other two things he pled guilty to. So, was it under the prison escape hoodie? No, it was under a new black hoodie I got from Courtroom Confidential. The zip-up black hoodie that says Courtroom Confidential on the pocket area, but there's no pocket there. No one recognized me. I have not been recognized as a celebrity pretty much anywhere. But I do think I should probably lay low. I was in khakis. I was in my khaki pants with a red shirt. That was it. They thought he's an employee. There's no way he would be stealing. That's why I got away with it. I was basically wearing a Target uniform. But nobody asked me anything. Like, excuse me, sir, where's this section? What do you feel when the justice system lets you down? Is this a dad joke? What do you do or feel? Are you being honest here, Joe Sherlock? Because I'm curious. When you say lets you down, are you saying that the verdict was not what you thought was fair or just? You know, I'm not a limited public figure. I was targeted at Target. He's going to get sentenced for his other guilties that he pled to right before this court started. The other 2 charges in the arraignment. Can we please see the link? Yes. Let me look. I have not seen it, so this is like a reveal for me. Amazon Prime orders. Mrs. R.A. has been buying her self shirts. Here it is. I think she chose a good one. Okay, there it is. One time only. You may now spy on Mrs. R.A.'s present, right there. And the lawyers make me say this is an affiliate link. If you do happen to click on the link and then buy something on Amazon on your same visit to Amazon, Amazon will reward me with a small token payment, saying thank you for sending customers our way. I will not complain if they do that, so feel free to use that link as a launching point for all your late Christmas shopping on Amazon. All right. Jewel, I have to stay off Amazon. My gift was bought there, and for once I don't want to know what it is. They are terrible at spoiling Christmas. I can tell you that. It is comfy. She wanted an oversized, overstuffed chair that she could just curl up with a book in. And it won't ship to Scotland. Oh, no. I'm sure you guys have other chairs there. It's a good choice. She chose it. I think it was a fabulous chair. It's definitely a book chair. It is. She already has the book reading lamp, and now that she has the chair. The only thing that would have made it better was to have an electrical outlet so she could charge her iPad while sitting in the chair easily. But I can take care of that with a cable. So, also works as a crochet chair. Yeah. Court's a little bit delayed this morning. I'm not sure why. Wish Amazon would allow you to hide a purchase using a password or something. Yeah, they just, for being the go-to destination for somebody's Christmas gifts, they sure don't work very well with secrets. Oh, I got cables. Here we go.
Hear. All present for the Honorable Diane Frenier, Justice of the Norfolk Superior Court. Brought here to your attention shall be heard. Let's have a call of Massachusetts Honorable Court. Please be seated.
Court's now in session. Didn't say turn off your cell phones.
In the matter of the Commonwealth versus Brian Walshe, Norfolk Superior Court, criminal indictment number 2023-0091. Defendant and counsel present in court. Defendants represented by Attorney Larry Tipton and Attorney Kelly Porges. Commonwealth is represented by Attorney Greg Conner, Attorney Ann Yaz, and Attorney Tracy Cusick. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Conner for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yaz for the Commonwealth.
Good morning.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning.
Good morning, Your Honor.
Good morning.
Larry Tipton for Mr. Walsh.
Please be seated.
I'm surprised he's in civilian clothes. One last time. Do we expect an allocution? Is he going to tell all? Is he going to speak? Is he going to say, I wish I could have pled guilty to this?
I have two motions up here, one from each of you, and I'll address those in a minute.
You are unmuted.
Now we can talk.
So let me start by, excuse me, taking a drink of water.
Always a good idea, Judge. I'm a big
Let me
fan.
start by listing what the court has reviewed in preparation for this sentencing to make sure that everything you think that I have reviewed, I have in fact received and reviewed. So I've received the parties' sentencing memos. That comprises one sentencing memo submitted, I think, yesterday or the day before, late in the day before, from the Commonwealth. The defense has provided a sentencing memo along with a supplement that I received this morning. I think that was filed yesterday after the close of the business day. I also have received various victim impact statements in writing, to include victim impact statement on behalf of the three minor children from the Department of Children and Family Services, DCF. I've also received victim impact statements written from Melissa Kirby and from Peter and Pam Kirby. And I sought out and shared with the parties and have reviewed various sentencing commission information, as well as guideline calculation from probation, as well as Mr. Walsh's carry and triple I, which I'll talk about in a little bit. And I've now just received and will review, prior to deciding my sentence, a letter from Diana Walsh. As an initial matter, is there anything that the parties submitted that I didn't just now list that you expected me or want me to review before sentencing? Kamal first.
Your Honor, there will be a victim impact statement given by Anna's sister, Alexandra Dmitrievich, and she's prepared to give that to the court.
Okay, but as far as written materials, any other written materials that you are hoping me to review before I impose sentence?
No other written materials, and I just want to note that FTR is not on at this point in time, and I don't know if the court needs that on. I know we have a court reporter, and we're in good hands, but sometimes we've been running both.
All right, I thank you for pointing that out. We do, when we have the court reporter, that is the primary method of memorializing the events, but always good to have a backup, and I see that Madam Clerk has put it on now. For the defense, are there any other written materials that you wish the court to review?
You have everything.
All right, let me just take a moment to review this letter.
We're going to back up a bit, sorry.
Impact statement given by Anna's sister, Alexandra Dmitrievich, and she's prepared to give that to the court.
Okay, but as far as written materials, any other written materials that you are hoping me to review before I impose sentence?
No other written materials, and I just want to note that FTR is not on at this point in time, and I don't know if the court needs that on.
Yeah, we got
I know we
that
have a
part.
court reporter, and we're in good hands, but sometimes we've been running both.
All right, I thank you for pointing that out. We do, when we have the court reporter, that is the primary
method of memorializing the events, but always good to have a backup, and I see that Madam Clerk has put it on now. For the defense, are there any other written materials that you wish the court to review?
You have everything.
All right. Let me just take a moment to review this letter.
All right. I do wonder if he's going to speak. There's a possibility that he will, in fact, talk. We did discuss that it's possible that in Massachusetts you're not able to plead guilty to first degree to capital murder. I still have not understood that fully. Some people say you can, some people say you can't. It would seem weird that you couldn't. That it forces the state to go through a process where you want to plead guilty, but you might be found not guilty. Barb, we saw the conclusion with April. She's in custody and hopefully going to be released to treatment. Agree, Agony Goose. He could have gotten up and testified in his own defense to his own detriment if he wanted to, and he didn't. Judge is reading all the letters. Who's the coffer in court?
All right. Thank you. We'll start with the Commonwealth's presentation of whatever victim impact statements that you wish me to hear orally.
Thank you, Your Honor. The Commonwealth would ask Alexandra Dimitrovic to address the court. Would you like her at the witness stand or from the podium?
In the witness stand.
Thank you, Your Honor.
Sorry, I'm trying to perfect everything here, and it's taking a bit.
Good morning, Your Honor.
Good morning. You may be seated.
Thank you. Thank you. Good morning, Your Honor. Good morning, everyone. My name is Alexandra Dimitrievich, and I'm the sister of Anna Walshe. I am here today to represent myself and my mother. I want to share with the court how losing my sister in January 2023 has forever changed our lives and left us with an unbearable emptiness. Losing my sister Anna so unexpectedly has altered our world in ways we never imagined. Anna was not just my sister. She was someone I grew up with, someone who knew me in ways no one else ever will. I struggle with the grief that comes without warning, hoping every morning that this is all just a terrible dream. The most painful part of this loss is knowing her children must now grow up without their mother's hand to hold. They now face a lifetime of milestones, big and small, where her absence will be deeply and painfully felt. This tragedy has also devastated my mother. She has developed severe depression and chronic exhaustion. Every single day, she carries the weight of losing her daughter. Our entire family is still learning how to live with this emptiness. Holidays and birthdays are now silent reminders of her absence. Because of the circumstances of my sister's death, we were denied the opportunity to say a final goodbye and to observe our customs, adding a layer of profound, unfinished grief to our loss. Anna was a mother, a daughter, a sister, and a friend. Her life was unfairly taken. We miss her beyond words. While we recognize that no sentence can bring her back, we ask the court to consider the permanent, long-lasting impact this loss has had on our family, especially her children. We stand in agreement with the Commonwealth and their recommendations. Finally, I would like to extend our deepest gratitude to the investigators, the Commonwealth's office, and everyone who has worked tirelessly on this case. Your dedication to seeking justice for my sister has provided our family with a sense of support during our darkest hours. Your Honor, thank you for allowing me the opportunity to share the full weight of this incomprehensible act. Anna will never be forgotten. We will carry her light and her memory with us forever. Thank you, Your Honor.
Thank you.
Thank you.
Wow.
Yes. Thank you.
Speaking for the family.
Sorry.
The bailiff really should have been up there to help with the chair as he did through everybody else.
Your Honor, we have no other victim impact statements other than the ones that we've submitted in writing.
All right, thank you.
Which, some of those are sealed. The children's victim impact statements are under seal. Brian doesn't even get to keep a copy. He can read it, but he doesn't get to keep a copy.
Right.
Is he going to speak?
I have read the Commonwealth sentencing recommendation, the written recommendation, but I'll have you state it on the record.
Thank you, Your Honor. The Commonwealth is requesting that the defendant be sentenced to a series of consecutive sentences on the charges to run from and after his federal case, in which he received a sentence of 37 months in February of 2024. The first charge that the Commonwealth would seek an incarceration component on is count 003, and that the defendant be sentenced to 2.5 to 3 years. The second charge would be that he, on the misleading 002, to run from and after 003, that he receive a sentence of 18 to 20 years. And that the third charge, the murder, in the first degree, that the defendant be sentenced to life without the possibility of parole to run from and after 003 and 002. And, Your Honor, if I may be heard in our argument.
Please.
Thank you, Your Honor. When you look at the facts of these three charges, each one calls for a harsh penalty. If you look at the illegal conveyance of a body, the defendant did not just, the person that he illegally conveyed was his wife and the mother of his 3 children. And he did it by removing her remains from the family home and placing them in buckets, in garbage bags, in dumpsters around the Commonwealth. He denied, as you just heard, her family the opportunity to have any customs or burial. There is no grave, there is no memorial. And he did this all in an effort to destroy evidence. On the misleading component, Your Honor, while we do mention the potential of probation, we put that in there only as data so that you understand the efforts that went in to trying to find Anna based on the defendant's series of lies. These lies were all done in an effort to cover up his crime and destroy evidence. We're also, while we put in that, we are not seeking a probation sentence, but we put it in there so the court, if it wanted to contemplate one, understood there was an option to do it that would prevent the defendant potentially from trying to profit from this.
So the only mechanism for me, as I see it anyway, the only mechanism for me under the restrictions of state law.
Yes, Your Honor.
It's an either-or situation. That is, either I incarcerate him for an additional period of time, either concurrent or consecutive, or I put him on probation following the life sentence, or maybe it even starts today. But the only way that restitution can be achieved on count 2 is through a probationary sentence. So I don't think there's any other mechanism for me doing that. So I don't know how you achieve that goal if without a probationary sentence and mandating it as a condition of probation. And so I wanted the Commonwealth to be clear with me. You're making note of it in passing, but you are not asking me to put him on a probationary sentence. Is that correct?
We are not, Your Honor. It is data that you can use in order to determine the scope of his lies in which the police relied on them. And you can see the costs that went into investigating the disappearance of Anna Walshe, but we are not asking for probation on this matter.
And the same question with regard to the issue of restitution that I heard rumblings of yesterday.
Yes, Your Honor.
Same result?
Same result. It is, again, it's data for you in determining your sentence, but we are not asking for it.
All right. Just wanted to be clear on that.
Thank you, Your Honor. And then on the murder, again, this was the murder of his wife and the mother of his 3 children. And the cover-up of this murder, Your Honor, deserves some analysis. If you look at the first internet search, which occurred at approximately 4:52 a.m. on the 1st, how to dispose of a body, and how they evolve into eventually 11:24 a.m., how to dispose of body parts after a murder, it appears the defendant at this point in time is committed to getting rid of evidence of the crime. And it leads to the shopping sprees later on that night at Lowe's and CVS and Stop and Shop. However, if you look at the internet searches on the 2nd, how to dismember a body, and is a hacksaw the best tool to dismember a body? It's a reasonable inference he hasn't started the action yet. And it results in the second shopping spree to Home Depot that afternoon, which means that Anna Walshe has been dead in that basement for over 24 hours. The same home his children are in, the same home the babysitter's at, the same home his mother has come to visit. And in the evening between the 2nd and the 3rd is when the dismemberment occurs, and on the 3rd we see him going to dumpsters, getting rid of the remains. In the defendant's sentencing memo, and I want to note, the defendant was represented by 2 excellent lawyers who are titans in this industry, who I have the highest respect for. They say the Commonwealth's recommendation is inhumane. I suggest that that's not the appropriate word choice, because if we were to look at that word, I would suggest that that describes the defendant's actions and the depravity of his actions of murdering his wife, dismembering her, and getting rid of her remains by throwing her away like garbage. The question might become whether or not this is a cruel and unusual punishment that the Commonwealth is recommending. And I direct Your Honor to one case. It's Cepulonis, Cepulonis versus the Commonwealth, 384 Mass 495 at 497. It's a 1981 case. To reach the level of cruel and unusual punishment, the punishment must be so disproportionate to the crime that it shocks the conscience and offends the notion of human dignity. I don't know if that's possible in this case, Your Honor, because human dignity was completely offended by the defendant's actions and how he treated his wife, how he disposed of her, and how he robbed her family and friends of the opportunity to bury her. There is no death certificate. The church will not allow a funeral to go on at this point in time. We are working on trying to work with the ME's office to see if we can get a death certificate to issue now, based on the conviction and based on the plea. And when I looked behind me after the closing arguments, I realized that that was the closest thing that those people had come to a wake, because they never got together to mourn her. And that happened 3 years later. So with that, Your Honor, the Commonwealth does make a punishment that we recommend to you. We recognize it's harsh, but we think it's appropriate based on the facts. And I appreciate your time, Your Honor. Thank you.
Thank you. I'll hear from the defense.
With respect to the first-degree murder conviction, although we made it clear from our memorandum that we do object to a life without parole sentence based on state and U.S. constitutional grounds, based on the Eighth Amendment, we understand the court has no discretion. With respect to indictments 2 and 3, you do. I think inhumane is the right word, respectfully. To sentence someone to prison posthumously to send a message is humane. It's dehumanizing him. Regardless of what happened in this courtroom, regardless of the convictions, regardless of what anyone believes about this person, he is a human. He is a father, he is a son, and he has been a friend to many.
Who did she look back at?
The life sentence is mandatory, but to do consecutive sentences, I think, is inappropriate and is inhumane. Anytime there is a death, a murder, a loss of life, it is horrible, whether it's a loved one or a stranger. And the legislature has provided, regardless of our disagreement, that a life sentence without parole is mandatory. But that does not negate that he is a human being. And I don't think sentencing him to on and after time is appropriate. Just because you can doesn't mean you should. What he was convicted of were atrocious acts. We've heard from her family, we've heard from her friends. Their pain is unimaginable, and I'm not demeaning that, but I have the opportunity to speak for Brian today. And I'm asking the court to sentence him in line with the guidelines and with the purpose of sentencing. Punishment, justice, prevention of future crimes, consecutive sentences, that's excessive and it doesn't meet those needs. So I'd ask the court to adopt the defendant's sentencing recommendation.
Brian?
I just want to put on the record that the defendant, in making its argument with regard to the inhumane aspect of any consecutive sentences, cited to a case in its brief, Donovan.
It's inhumane to have consecutive
Donovan
sentences.
does not apply to this case. As an initial matter, Donovan related to a larceny involving a single act that resulted in 7 different victims being victimized. The SJC, that was, I think, a 1985 case. The appellate courts in Massachusetts have long since distinguished Donovan, even in the case of larcenies, which is not the case that's before me, to recognize that even Donovan relates only to a single act case and not one with one purpose. As you could argue, there was one purpose here, but more than one discrete offense. So I'm not persuaded by the logic of Donovan, even if it applied to this case, and even if it was as broad-reaching as the defense suggests in its sentencing memo, which the court finds it is not.
Nice try, defense. It is hard to hear a defense attorney argue that punishing the criminal for the crime is inhumane when the victim is dead. And we're not talking about torturing the criminal for the crime he committed. We're talking about locking him up for the crime he committed, and them to say it's inhumane to keep him in prison forever. If he behaves like an animal that's out of control, where else would you put him? Sounds like the Donovan case she cited, a single act of larceny that had 7 victims, probably was overturned on appeal if the sentence was 7 different consecutive sentences for each victim with one single act. So
there is no task facing a judge that is more important or more difficult than crafting an appropriate sentence. The legislature mandates that the only appropriate sentence for the jury's verdict, murder in the first degree, is life in prison without the possibility of parole. That sentence is immensely appropriate and just, given your murderous acts and the life trauma that you've inflicted upon your own children. As to counts 2 and 3, I have wide discretion in sentencing. I want to state my rationale for your sentences on those 2 counts on the record now. I have considered various factors with regard to my sentence for counts 2 and counts 3, to which you pled guilty on November 18th, 2025. Specifically, I've considered the severity of the crimes, their nature and circumstances, and your role in those crimes, the need to deter others from committing comparable crimes, and your prior criminal record, namely your federal fraud case. As to the latter, your criminal history shows a long and well-documented history of deceitful and manipulative behavior. I've considered your character or lack thereof, your behavior, and your background. With regard to the nature and circumstances of the offenses, as to indictment 002, in the approximately 4 hours of interviews spanning 4 days, you concocted a detailed, completely fabricated story of what happened to Anna Walshe on January 1st, 2023, in order to cover up your murder of her and disposal of her body. Your lies triggered a multi-day, extensive missing persons investigation. A command center was set up in Cohasset and was manned by various law enforcement, to include the Cohasset Police Department and the Massachusetts State Police. And local and Massachusetts resources were deployed to Washington, D.C. to investigate at Anna's home. Because of your lies, thousands of hours of investigative resources were wasted and diverted from other deserving cases and investigations. As to the nature and circumstances of count 3, the improper disposal of Anna Walshe's body, the seriousness of your acts cannot be overstated. Your acts in dismembering your wife's body and disposing of her remains in multiple area dumpsters can only be described as barbaric and incomprehensible. You had no regard for the lifelong mental harm that your criminal acts inflicted on your then 2, 4, and 6-year-old sons, not only in taking their mother, but also, as is specific to this charge, in never being able to properly grieve that loss, to say goodbye to their mom. And I hear today the same is equally true of a sister who never was able to say a proper goodbye to her sister, a mother who never was able to say a proper goodbye to her daughter, and many friends who had the same loss. As to indictments 2 and 3, I have considered the sentencing guidelines, the aggravating factors. There are no mitigating factors in this case. And I also sought out and considered information from the Massachusetts Sentencing Commission, again, which I shared with the parties earlier this week, in particular sentencings in 2022 and 2023 of defendants who were convicted of murder and or voluntary manslaughter, along with a Chapter 268, Section 13B conviction. This is not a guideline case. Finally, as to the first-degree murder conviction, I have considered the loss of the life of an innocent, remarkable woman, Anna Walshe, and its devastating impact on her children, as relayed to me in the letter from DCF, her family, as relayed to me in her sister's victim impact statement today, friends in their victim impact statements, and the community. In the trial testimony of Jem Mutlu and Alyssa Kirby, a little bit of Anna Walshe, her warm, powerful, and embracing spirit came to life in this historic courtroom. I have carefully listened to the moving victim impact statement, to the oral written sentencing arguments made by the Commonwealth and by Mr. Walshe. It's clear to me that Anna was a bright light in the lives of many people. She lifted people up. I am sure that nothing I say and no sentence I can impose, even a life sentence, will lessen the grief that Anna Walshe's family, her mother, sister, and 3 boys, extended like family, confidants, friends, and others have endured and will continue to endure. Although I consider the letter of Diana Walsh, I simply cannot reconcile the person Diana Walsh describes in her letter with the person who stands before me for sentence. Mr. Walsh, you can stand.
Mr. Walsh is told to stand.
Mr. Walsh, you will live with the guilt and burden of Anna Walsh's death for the rest of your life. As to count 1, the jury having convicted you of murder in the first degree, I sentence you to life in prison without the possibility of parole. As to indictment 2, lying to the police in connection with the investigation of a life felony, I sentence you to no less than 19 years, no more than 20 years, the statutory maximum, in prison to be served consecutive to the life sentence in 001. The legislature caps the maximum sentence for the improper disposal of a body at 3 years in state prison. As to indictment 003, the improper disposal of the body of your wife, Anna Walsh, I sentence you to no less than 2 years, 364 days, and no more than 3 years in state prison to run consecutive to the sentences in 001 and 002. I want to make one other notation with regard to the sentences that I'm giving today. Earlier in this case, I identified that there was an error in Mr. Walsh's III. That error persists to today. Specifically, so the record is clear, as I understand Mr. Walsh's prior federal sentence, he was sentenced to 37 months in federal prison. That sentence was to run concurrent with any state sentence that was given in this case. This morning, I asked probation to run his III again, and it is still incorrect. It is showing a 5-year probationary sentence. At my direction, the probation department in the last month, or perhaps a little bit longer, contacted the federal probation office in Boston to correct what I think is an obvious error in his III. It has not been corrected, and it stands still today as showing 5 years of probation as the sentence. To the extent that confuses anything in my sentencing, I want the record to reflect that, again, it's my understanding he was sentenced to 37 months in federal prison to run concurrent with this sentence that I'm now imposing today. Madam Clerk, you may impose the sentence.
Thank you, Your Honor.
Are we waiting for the clerk to enter it in the computer?
Mr. Walsh, a jury having returned a guilty verdict on charge 1, murder in the first degree, you were sentenced to the state prison for the term of your natural life. Count 2, witness intimidation, you having entered a guilty plea to that, sir, you're sentenced to 19 years, not less than 19, not more than 20 years, to run from and after your life sentence on count 1. On count 3, improper disposal of a body, you are sentenced to not less than 2 years and 364 days and not more than 3 years to run from and after the sentence on count 2. You will receive 1,076 days credit for time deemed served while awaiting the disposition of this matter. All fees and fines in this matter are waived. You're all set, Mr. Walsh. Thank you.
Thank you, counsel.
Look, right.
Goodbye.
Goodbye. What an appropriate ending to that one. He doesn't seem upset. Man. I'm not sure what the deal is with the messed up triple I, the federal thing that shows his sentence. He was in custody on his federal case, on his fraud case when this was taking place, and for that to show that he should just be on parole. The judge is confused and saying, I don't want him to be let out on his federal side, saying, hey, you're supposed to be on parole. The sentence he's supposed to serve now is concurrent. This means at the same time. He starts the life sentence at the same time. So they can't let him out because he's also serving this on the state side. So there's no gap there. She's not going to run it consecutive to the federal one in case for some reason they let him out, which would be no bueno. Wow. What a... He didn't blink. I mean, he didn't shift. He did nothing. He's just... It does seem that either he's just completely steeled himself to this or he's just completely heartless. I think the appropriate punishment was given that the judge did not have an option. Life without parole is the only thing she was legally allowed to convict him of. So, some of those victim impact statements might be published at some point. We might keep an eye on the record. I'd like to hear what his mom had to say about him. How did she describe him? That would be interesting. But with that concludes the Brian Walshe trial, and we are still early in the day. It's only an hour into our day, so we're going to go ahead and jump to a court, which we haven't been to in a while, to do a little court hopping. If you haven't been court hopping with us, please do. There are crazy things happening in little courts all around the nation live right now, and we will take you to some of them. We're going to start with what we call the standing judge,
We didn't even know
Judge Oakley, who sometimes swears at people.
Because she emailed the day of the hearing.
So it just depends on how.
Yeah. Mohammed's and Ayden. Morning, Counsel.
Morning, your staff. You're acting representing Mohammed Zainuddin. One of the president is standing to my right.
Thank you.
They were pre-trial conference, and we'll wait for him to stand up for arraignment purposes, and he's resolved the matter. Has the responsibility to double
bargain. Awesome. I'll accept the plea to the civil infraction, dismiss the misdemeanor, send you downstairs to deal with the cashier and get a smile. You all set, gentlemen?
Apologies to you guys.
Thank you. You too. You're welcome, sir. Mr. Starr, I am ready on Senarowski. How do you say it?
It's quite the name. How do you say it?
Sir, can you tell me your name?
Ricky Lynn Shatner.
Thank you. Go ahead, Mr. Starr. That guy. I got you.
Yeah, this is Raymond pre-trial. Stand you wait for me. Come to a resolution whereby he will plead guilty to allowing a suspended person operating motor vehicle reduction from the drive while license thing.
All right. Mr. Senarowski, did you understand your rights and options after discussing those with Mr. Starr?
Yes.
You understand the possible penalty for the charge?
This is Judge Oakley.
Are you pleading guilty to the charge? Freely and voluntarily today? Did you drive a vehicle on November 19, 2025 in Van Buren Township?
Yes.
At that time, was your license suspended, revoked, or denied?
No.
I'll accept your plea and dismiss the original charge of drove while license suspended, revoked, or denied. Are you working or retired?
I'm working. I had to go back to work.
Okay. Where are you working at?
Bus transportation.
All right.
Bus aid.
Okay. How long?
Gosh, I've been here since.
Does he drive buses?
Okay.
I was off for 2.5 years medical.
Okay. And went back.
forward.
Okay. Anything else? Anything else you want me to consider?
What?
Anything else you want me to consider before I sentence you?
I've been homeless since June. The car was my bed, along with my mom.
Mm-hmm.
When she died, they brought it over to my trailer. Left it there. And it sat there for a couple of years. They came in June and evicted me from my trailer. So the car was more or less my bed.
Right.
They had to move it out of the park. I stayed in several places in the car. I've been kicked out of a lot of places in the car.
Mm-hmm.
We're in Michigan, by the way.
Right.
Can't tell from his jacket.
Right now, I'm staying in Studio 8 here in campus on Michigan Avenue. I had to do something, got too cold to sleep in the car.
Sure.
And I managed to get my job back after 2.5 years on it.
Right.
Yes, I did. Yeah, Steve, I thought so. Yeah, that Army had. He served in the military.
All right. I'm going to suggest before you get out of my building today, downstairs, ask somebody behind the counter to speak to Avery Taylor. Mr. Taylor will have some resources to share with you about some temporary housing. I'm not saying it's going to work, but it's something to look into.
Yeah.
Well, ask him anyhow. Ask him anyhow. All right. Anything else?
He did apply. He informed me he applied right after this incident to try to get the hearing.
Right.
This resolution will keep that in mind.
Right. Good. All right. Anything else? All right. I'm going to suspend your fines and costs. Good luck. You're welcome.
Judge Oakley.
What's that gentleman's name?
Avery Taylor.
Gives him a pass.
Jared Carr. Mr. Carr, are you going forward today without benefit of a court-appointed attorney?
Oh, man. Pro se.
Says here you met with the prosecutor. You're going to plead responsible to an added charge of double parking. You've agreed to pay fines at cost of $500. I'll dismiss the misdemeanor. Is that your deal? Can you pay the $500 today? Yes? Go downstairs, take care of that payment, and get on your way. Enjoy your day. You're welcome, sir.
Cha-ching. The last guy got his fines waived. This guy pays $500. Also driving a fence. Double parking.
First one of those I've ever seen.
What is it?
Oh, yeah.
Fairchild?
Another Michigan shirt.
Our established law, P16, 16 fair trial. There are big debate concept for final pretrial prosecution is unable to proceed with the asking for dismissal.
Granted. Mr. Fairchild, this case is dismissed, but we've got another couple of files that you owe some money, or one file that you owe money on. A drove without due care and caution. You got a payment plan? What, as of when? Oh, brand new. That's why. Yep, you're okay then. You're all set. Have a great day.
We were going to lock you up
Thank
until you
you
could pay. But he's going to play. He's going to pay. It's no coincidence.
Humphreys.
The court hopping logo looks a lot like Mountain Dew.
This is currently approaching. All right, this time we're asking for final pretrial date of January. February 11th.
That's on both files, yes?
Yes, ma'am.
Complainant to appear?
Yes, ma'am. The
You in a relationship to Derek? What was the date, Heather?
January 8th at 10:20. And I'll mail notice.
Thank you.
Judge has the ultimate standing desk.
Jennifer Kroger.
And he said, we can do that for this against never.
All right, Ms. Grover, this will be dismissed without prejudice. It looks like you've got another trial or another case with a trial coming up January 29. You know about that one?
Should.
Okay, you're all set. You're welcome. You're welcome. Tony Raths?
It's judge's business. Gets it done.
Raths, R-A-T-H.
Your Honor, Bill Close, 838434, on behalf of the defendant, Mr. Rance, would you please, myself, the question? Oh, right.
Good morning, gentlemen.
Your Honor,
February date?
A pretrial?
Yeah. You just want to adjourn the pretrial?
that's correct, Your Honor. I talked to the prosecutor. I think she looked at something and she said February 26th would be a good day of this every time. But we know who the real judge is right over here on the left.
February 26th is a good time, good date to start.
What time?
We can do 9 o'clock.
That sounds
All
good.
right, Mr. Rath, just have a seat. We'll get your paper notice.
Judge, thank you.
You're welcome.
Nice holiday.
You as well. You as well, Bill.
Isn't that this afternoon on the Mickey Steins?
Mr. Garcia, we're good.
He's still waiting to speak to an attorney. That's with Sam the resident.
Can't tell Frazier. We got a plea agreement on this one?
I'm just asking for a withdrawal.
Okay. Ms. Frazier. Good. Mr. Jadala wants to withdraw. Any objections? That means he's not going to represent you.
Who is?
At this
time, nobody.
At this point, nobody's going to represent you unless you hire somebody, because you've been through at least 3 of ours, and you can't seem to get along with people. So, okay, okay. Okay, he's just asked me to withdraw. I've let him. So he's done. He's done with this case. He's done with this case. Okay. So the question is, do you want an adjournment so you can hire an attorney, or you just want to talk to the prosecutor and do it on your own?
Yes, I need to talk to her, but she got evidence though that she ain't replying to you back. So yeah, I need to talk to her.
Okay. Okay. Go out and talk to the prosecutor.
You've burned through 3 public defenders, and none of them want to work with you anymore. It's not them. It's you.
I'm dismissing McKinney.
Simpson and Oakley are in the same area of Michigan.
How much was it lunch? I hope it will be an update. Okay, I just want to make sure because I know I don't know this, so I need to make sure other people have to listen. All right, I just want to make sure the past couple that I've done, unless they're just bypassing the counter, but the past couple I've done, they're not updated. It doesn't say the paper. Okay, I'll make sure. Judge, and then we have West Group, W-E-S-T, and the attorney's on Zoom.
Counsel, we ready on Westrick?
Yes, Judge.
Your appearance.
Thank you. May it please the court, Sergeant Khan, P65487 on behalf of Mr. Westrick, who is also appearing via Zoom. Mr. Westrick, can you please turn your video on and unmute yourself?
Show yourself, sir.
Hello.
Thank you. What are we doing, counsel?
We have your profile.
Your Honor, I've had an opportunity to speak to Mr. Mena. We've discussed the matter. He has made an offer to plead a double parking with stipulation of $400 in fines. The weapon that was confiscated will be kept and destroyed.
Whoa.
And Mr. Westrick, is that the way you want to resolve this today?
Yes, sir.
Beats a weapons charge, but...
And can you pay the $400 online?
Yes.
Can you do it today?
Yes, sir.
That's a sweet
All right.
deal.
Then I'll dismiss the misdemeanor. Anything else, counsel?
No, Judge. Thank you very much.
Enjoy your day.
The second guy we watched in this court
You as
had
well.
to pay $500 for the same offense, and he didn't
can
have a
make
weapons charge dropped.
Okay.
Is that roughly young?
Yeah, Jamie's out there.
This court can go from quiet to loud really fast. Might head down to another judge here in just a second. Judge Goggins.
There's nothing getting out of the prosecutor. She'll have to be advised of her rights.
Okay. So, Ms. Frazier, here's the question. Ms. Frazier, here's the question. Do you want me to adjourn the pretrial so you can hire your own attorney, or do you want to just, pardon me?
I'll my own because it's evidence that y'all.
Okay, 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 all right. All right, I don't have any evidence.
She came with an attitude.
All right, so you want to represent yourself? All right, so
that's a mistake.
Let's set it for trial. Do you understand the difference between a jury trial and a bench trial?
So I'm like the paying for it.
Pardon?
Leeway.
Okay. Okay, is there a question there for me? I'm sorry. What's the question?
Hire leeway to run a meeting.
You mean, can you hire one of our attorneys that are in here?
Leeway, the state.
I don't know if you can hire them or not. I don't deal with legal aid.
Set that. Okay. All right.
You can hire anybody you want to. I'm not.
Yes, sir.
Yeah. So, all right. So you want me to give you another date so you can hire an attorney? All right. I can give you a February date. That gives you all the month of January to get somebody lined up.
Yeah. I'm also reading drop out.
Okay, but I'm not going to make somebody talk to you.
I was no.
I guess I'm be able to speak to prosecutors more than that.
So, can I have a February pretrial date?
With Judge Martin.
Wow.
Judge, she wants to speak back to Sam, or I don't know if that's a good idea.
Oh, I know it happened.
I think
You never told me about drop. You told me.
Let me ask you this. What does it matter? He asked me if he could withdraw. Obviously, he doesn't want to represent you. And I said yes. So he's off the case.
Off the case.
What's it matter? You want me to tell you? I'm going to tell you why. You've got a bad attitude. You can't get along with anybody. You've gone through 3 of our court-appointed attorneys. Ma'am, you asked. I'm telling you. So I'm going to give you a court date. It's going to be when? February? Ma'am, do not talk.
February 12th.
February 12th. What time? 9 a.m. Have a seat. We'll give you a paper notice, and then you're going to leave my building without talking to anybody. Are you clear on that? Ma'am, you're going to take your notice, and you're going to leave my building. Ma'am, I'm talking to you. I'm talking to you. Do you understand that? We're going to give you a notice, and you're going to leave the building without talking to anybody else. No, you're going to sit down right there, and I'm going to give you a notice, and then you're going to leave my building. You're not going to stop and collect $200. No, you're going to leave my building. Any paperwork you want, you can get online.
Wow. Do not pass go.
You're going to sit there, and you're going to be quiet, and you're going to get your notice, and you're going to leave. Anything other than that, I'll hold you in contempt.
You burned through 3 good lawyers who just can't work with you. It's you. It's you. Oh.
Heather, this Abdallah that you gave me earlier today that somebody made a deal on, there was a double parking.
Angela took a plea.
So that's the little note, 14 days. He's 14 days to pay his $350.
That's the plea for the business to gonna get it under control on 26. In one of the files, they have the prosecutor as 7337. So I kept doing it, and I kept doing it. I kept coming with the wrong person.
Well, she's standing there filling in on that lady that was so screwed up.
Yeah. Just wondering if you want to write on the blue ROA for the civil infraction. If you write on the, might have wrote on the piece of paper. Oh, okay. The warrants all canceled. The warrants were, I moved them. This wasn't, yeah, they were all canceled in lien. They just weren't canceled in. The PD canceled them all when she posted bond with them. We just did not go through and cancel them. Or collect the bond. So, together, so.
All right, as this court has a
for
lull,
that.
we might jump somewhere else. Got a couple
No,
of
it's all right.
And then I called.
Training exercise, right?
It is good. The two people that I double checked, they're not putting that they checked them in, and I'm mailing all notices.
Yeah. Okay, we're jumping. Goggins, Judge Goggins, what's happening with you? Are you there, Judge? Are we off the record? What? Not hearing anything. Might have to jump to another one. Just 1 second. Yeah, we're gonna jump. He hasn't had sound all morning. Okay, thank you for that. So his audio's not working. We're gonna jump back just a little bit and check out Judge Sheila Johnson then. See what she's up to. I know it's some landlord-tenant issues, but she can get spicy too. Up in Michigan as well. Southfield
Case number
District Court.
2508427 LT. And this is Ola Davis versus Julius Phillips.
LEB, thanks for the advice on the broken chat. YouTube is having some issues today, so sorry about that. Some people are being told they can't chat even though they're members. They say you have to be a subscriber first. We know you're a subscriber. It's a YouTube
Switch
thing.
sides, please. You're on this side, ma'am. Slide over. Ma'am, just move over. This side is for the plaintiff, okay? And this side is for the defendant. All right. What is your name? Okay, Ms. Davis, good morning. What's your name, sir? And Mr. Phillips, good morning to you. And let's see. You're both here today for a landlord-tenant hearing. Let's see. This is for non-payment of rent.
It's usually what it is.
All right. It just says defendant's going to leave. So what is it that you discussed?
I wanted him to move out.
Okay. Does he owe you some rent?
What if he told you?
Okay. Well, you don't have the amount listed here to enter your judgment. You filed this as a non-payment of rent case, which means you're seeking rent. And if he doesn't pay the rent, then you get to evict him. This is not just a you got to move case. This is he gets to pay rent and stay. If he doesn't, that's not what you filed. I'm telling you what you filed. So now he gets to pay rent and stay. And if he pays, he stays. And if he doesn't pay, then you get to evict him. Was it your intention to do something differently?
Yes. Doing what the policeman told me.
Who?
Policeman.
Policeman. They told you to file.
And he'll be evicted in 7 days.
Don't take legal
Okay,
advice.
that's not how it works. Obviously, you have to give him a notice. And it could be, it depends, a 7-day notice if it's for non-payment of rent, but he's not evicted. You just get a court date. And then we go through this process. Then he gets if he owes rent, you get a judgment.
Well, she moved out the first.
Did you move out already?
I did not.
You were gone.
Apparently still there, like, as
You
of
just
today.
came back just about
Oh,
2 days
left the
ago.
residence this morning, went to work, left my job to come to this court.
Okay.
Moved out the 1st of December after he stole money out of my purse. And then he brought his girlfriend to my house because he thought I was home, and I'm his girlfriend. So that's why I want him to move out.
Okay.
And he's destructive. He's tearing up appliances. He was going to steal aluminum from the furnace. He brought his friend over.
Really?
That's why I want him to move out.
Okay, well, you didn't file it as a, there's two kinds of ways you can file these cases. You can file it to terminate them, which means just get them out. You're not looking for money. You filed it as a, I'm looking for money case, and if you don't pay the money, then you move out. You just wanted them out. You weren't looking to get money right away.
He brought his girlfriend,
Pay money.
thinking I was gone.
Okay. So,
But I'm
ma'am,
his
let me
girlfriend.
explain to you. Wow. Two things can happen. You have filed the wrong case. So you got to dismiss this case and file the other kind of case to terminate the tenancy.
That was him in the house long ago.
Well, ma'am, you don't have an amount of rent for him to pay in order for him to move. You don't have a lease. You don't have any type of, I guess, ma'am, I get all of that. I have cases like this all the time. People are kicking out a boyfriend. They're kicking out their children. They're kicking out their friends. Somebody that's not supposed to be there because they own the house. That's fine. You can do that. I'm trying to tell you, you filed the wrong kind of case to do that, though.
So I need a
Termination of tenancy case to get possession of property, not a non-payment of rent case. Now, there's one thing you could both do. You could stipulate to convert this to that.
That's what it said. There's one for you left out.
Would you like to stipulate to convert this to a termination of tenancy, and then you all agree on a move-out date? You could do that.
That's not what I would do, but I also like to add some.
Well, wait a minute. Who owns the house?
She's not the homeowner.
Who?
I am the homeowner. This is my son's house. He's not a tenant.
If you look up the address, you find that she's not the homeowner. It's under Donald Allen.
That's my son.
Okay, well, where's Mr. Allen? Where's Mr. Allen?
He hardly knows about him. We only know.
Okay, well, if this is going to be your defense that she doesn't own the house and she don't have a right to kick you out, is that what you're going to say?
He told me.
She's saying I'm not.
Okay.
If I don't.
Do you have a lease?
No.
Do you have a course of conduct every month that you're supposed to pay a certain amount?
We had a verbal agreement, but not only that, I've been actually writing down the amounts that I've been giving her on a piece of paper and having her sign her signature on it. I also have been taking photographs of when she goes to Fifth Third Bank to make deposits.
How much are you paying monthly?
Don't take photographs.
Excuse me. Wait a minute. I understand this has gone wrong as a relationship goes, but we got to get to the facts here. Oh, no, ma'am, I can't handle that today. That's a different case with the police. So we're just here to see if he owes rent or not. And if he does, determine what that amount is and to put that into a judgment and allow him to pay any back rent. And if he doesn't, he gets to move. So you filed it as a non-payment of rent case. He says he is paying rent. If you all need a trial on what amount it is that should be paying and that he's behind on, we can do that because that's what we're here for. Is he behind on an amount that he should be paying based upon your course of conduct between each other? If not, you can dismiss this case and refile it to just terminate his tenancy for whatever reason you want. You got to give him a 30-day notice, though. Since he doesn't have a lease, you got to give him 30-day notice, and then you could proceed on that kind of case. So you got to decide, ma'am, what do you want to do today? Do you want to, he's saying he's paying rent. Do you want to proceed and try to figure out how much the amount of back rent he owes you? Or would you like to dismiss this case and file the other kind of case? Which would mean you'd be back sometime probably in January.
So I do want him to pay as long as he stay there, but I want to.
Well, okay, you need to be telling me how much is the unpaid rent.
$770 plus $386.
$770 in unpaid rent for what months? How much does he pay monthly?
Supposed to pay $770. So he didn't pay last month.
That's not true.
Okay, well, sir, that's what a trial is for. So if you're,
I'm calling right now, for me giving her $600 cash. Right.
but that's not 770. Is there?
That's not what we agreed on. That's
Okay. All right. So I'm going to need a trial date here.
Let's go to trial.
I can't resolve this today. This is a trial issue. So, ma'am, if I don't do it today, tomorrow, or Monday, I'm going until January. And I can't do it today because this is a landlord-tenant docket. It's not an actual time to take testimony. We would have to put it over. Tomorrow we have a docket, and Monday we have a docket. So you're gonna have to wait until January. We can ask him to pay escrow, which the rules allow, and he could pay escrow of 1 month's rent to the court. What is that, sir?
Photograph right here of her being in the car. We also had a Fifth Third Bank.
Okay, but this is not the trial. You don't have to show me any evidence today. You can wait till the trial date. So if we either going to do two things, I'm going to give you a trial date. If you choose to between now and then, you could dismiss this case and file the other kind of case where we don't care what the rent is. We just want to evict him out of the house. That's your choice. Okay, man, but you got to file that case. You got to go give him the 30-day notice, which means basically if you did that today, you could file your case in January and it'd probably be heard the 1st of February.
The termination?
Yes, because you have to give him 30 days notice. 30, not 7.
Well, why would tell me?
7 is for non-payment of rent. 30 is for termination. You weren't talking to a lawyer.
You're talking to a police officer.
So I want him.
Okay, ma'am. Listen, I'm going to give you a trial date. You need to do this. Give her the yellow sheet there. Charles. Yeah.
Charles. He don't need to be left in my house.
You can't put him out and I can't put him out because ma'am, this is the process. You have to go through the court to do this. I can't just put him out without going through some process. Due process rights. You ever heard of that?
Great.
He says he's still there. Ma'am, no matter what you tell me, I cannot give you a judgment today to evict him. There is money owed, so he says and you say. You filed it as a money case. We need to determine what the money amount is. You people do not agree on what's the outstanding money. That means you need to have a trial. Excuse me, that means you both need to have a trial. Sir, we're not going to have a trial this morning. She got to present all her evidence. And I don't know what the course of conduct is between you people.
Just dismiss this case because I have
she has to do it and you have to agree to do it. Do you want to dismiss this case and start over with the other kind, or do you want to have a trial on this case about how much rent is due, which we can get to you as soon as the 1st of January, like in 2 weeks probably.
Okay. I do this case, can I not accept the rent and then get him out?
What are you asking me? You want to get a judgment in this case?
Not accept the rent.
Well, what would be the point of getting a judgment and not accepting the rent? You can't do that. He has a right to pay it and stay. The only way you can not accept rent and get him out is to file a termination. If you file the termination, then you don't accept any rent, because if you do, that means he gets to stay. So you don't accept the rent, you file the case, we see who owns the house and who has the right to do this. Who has the right to evict him? Okay. Ma'am, okay. All right.
He trying to bring my son into something that my son is not involved in.
Okay, you need to take that yellow sheet and call legal aid. You need some help. And I don't know if they can help you or not, because they have their own criteria as to who they help. So I told you what types of cases you got and what you could have. You need to decide. Right now, this is pending on my docket. I'm going to go ahead and give you a trial date, and I'm going to give you an escrow order for $770 for January 1st, and it'll be prorated from December 18th to December 31st.
We didn't agree on that. We don't have any like documentation or lease.
You just told, how much do you pay? How much you just told me you were paying or something like that?
I didn't say $770.
How much you pay?
I was only giving her $600 a month.
Okay.
And that was basically $400 toward the mortgage, and the other $100 were going.
Show me some documentation that you were 6.
You gonna look at the photo that I have?
Whatever you got.
He wasn't at the bank, he sent somebody. So the person at the bank took this.
This is it right here. I just laid out $600 for her. It's hundreds, pinkies, and $20 bill up there.
Okay.
Right outside of Pickles.
But how do I know what this is? Sir, this is a picture of some money sitting on the, like.
Outside the bank, she's making a deposit.
What this is? I needed something from you that showed like you had a check or you had something that.
She doesn't want to take like a receipt or anything like that, because what was going on before is that when bills actually get mailed to the house, I was just going online, actually just paying them, have money taken out of my account.
Okay, so.
Now she just wants to do this straight cash and everything, but she doesn't want to give me a receipt and me paying her. So I laid this money out. I'm in this vehicle with her right now. So this just doesn't make any sense.
My money that you stole and gave it back to me? Breaks into my car, steals my money, and give it back to me.
Okay, so let me tell you what I'm gonna do. I am going to set this. We need a trial date, please. January.
Court's available January 8th at 3 p.m.
Okay, it's gonna be January the 8th, 2026 at 3 o'clock. Everybody bring what you need. You bring your lawyers. If you got a lawyer, you want to get a lawyer, I cannot give you a lawyer. You need to go to legal aid if you need a lawyer. If you don't need a lawyer, then come prepared for your case. Bring whatever you got to show whatever the agreement was for him to pay. You bring what you have about whatever the agreement was for you to pay. And whatever way that you have to account for the money that was given to you, if you have to write out a ledger of what you think you've received and what you didn't receive, we need to have something like that. We need to have testimony about what was actually paid and what was actually received, so I can determine if he owes money, how much and for what months. You, of course, don't bring me no picture of some money sitting in the middle of a console on a car. I don't know what that is.
That's the only thing I have, because I did have papers to where I had her sign her signature on there, how much.
Well, then that would be more likely, ma'am, excuse me, the way this works here, and I'm going to tell you this, I don't have this kind of nonsense at trial. Nobody's going to talk over each other. When I'm talking, you're going to shut up and you're going to listen. And if you keep talking, we're not going to throw any aspersions, casting aspersions towards each other. You don't have to like each other. I get it. This is going bad, which happens. But you're not going to disrespect each other in front of me. And you're not going to disrespect me by talking over each other and talking over me. And if you do it, I will be holding you in contempt of court. I'm telling you something, you better be listening. I will be holding you in contempt of court, and I will be either jailing you or locking you up that way or fining you. And I say what I mean, and I mean what I say. So we're not going to have no nonsense in here. We're going to be respectable, and we're going to talk. I talk to everybody kindly. And I expect that in my courtroom. I don't expect anybody. You don't have to like each other. You just got to be nice.
Oh, no, I was calling.
Like her. It's just that she's not being professional. Like I have 2 checks in my job.
Sir, good. Keep what you got and bring that as your evidence of what you think you paid and how you paid it. If you choose to dismiss this case before January 8th, that is your right to do that. You need to go get him to sign off on the dismissal.
Do I need to come up here?
No, we have a form that you can fill out and you can have it scanned in to our electronic system here. And if you don't know how to do that, you can come up here with the form for dismissal with both signatures on it, and they will help you down in the clerk's office.
That's something that I can get off your website or have to.
Do we have any dismissal forms up here, Charles? Can you ask Jessica? We can give you a form now, and the part that says stipulation requires both signatures. That means you're going to dismiss this case. You could start over with the other kind of case if that's what you choose to do. You need to call the number on that yellow
Kevin
form
from the
at the
office?
top. The rest of it is kind of irrelevant because that's for people looking for assistance. But the number that says Lakeshore Legal Aid is the number that you could call, and you could take one too, and you could call Lakeshore, and they can decide between the two of you who they're going to represent.
The homeowner is aware that I'm living there and the homeowner is not trying to evict me and me and the homeowner are on good terms. Then how does she have the right?
Sir, let me tell you both. I'm not going to decide this case by your questions today. You need to figure that out. And if you need to subpoena somebody to come testify, they got to come. So you need to subpoena somebody, they have to come. And if you want to subpoena somebody, you need to go downstairs to the clerk's office and get a subpoena, fill it out with that person's name and address,
Pay the fine.
and some contact information so that when you pay the court officer to serve it, they know where they're going, and they may have a phone number to contact the person if they need to set it up to serve them. If you serve somebody with a subpoena, they have to come. And if they don't come, that's a problem for them, including arrest.
Thing I want to ask. I didn't receive anything in the mail about me having a court date today. So is that something that's normal?
Sir, what I don't work for is the post office. I don't work for them. So I can't vouch for them. Okay. Because normally what happens is the court would serve a summons a complaint and or mail the summons a complaint. Who doesn't have to? Sir, listen, you're here. So it does. You're okay, but you're here. But you're here. Sir, you're here. What's the problem?
Well, the supposed to be here. You told me you're not coming.
Well, then you could have gotten a judgment if you had an amount of rent, but you don't. And he's here. So now we're setting a trial. Can we please set the trial date of January 8th? And I'm going to do an escrow order.
Of 600? I love the.
What is it, ma'am?
Picture of some money. That's his receipt. I took a picture of the money.
That he should move.
Well, he might get to the point that he has to move. We're just not there yet.
Because there's other things going on that it's too dangerous for him to stay in the house.
Ma'am, what do you want me to do about this? I can't do anything. I told you today, no matter what you say to me, I can empathize with you, but I cannot do anything. We're not at the point of trying to evict him. We have to have it because of the type of case you file. I'm going to say this for the last time. There are other people sitting here that I'm going to move past this case and I'm going to move forward for them. But I'm going to say this the last time. You have filed the wrong kind of case if you're trying to get him out immediately. This is a case for non-payment of rent. He gets to pay and stay if we determine that he owes back rent. If we determine he owes no rent and he's up to date, your case gets dismissed and he still gets to stay. The only way he gets to move out in this case is if there is unpaid rent and he doesn't pay it within 10 days of the judgment date. Then you could come and evict him. That's how it works here.
Judge's going to make him pay into escrow. No more pictures of money. That's proof that you paid the bill. It's just a picture of a couple $100 bills. It's not a receipt. Oh, my goodness. I'm guessing they're not exchanging gifts. doing all this while wearing a winter hat with a big pom-pom on it. That's impressive.
So I'm going to enter an escrow order for $685. That is the split of the difference between the $770 that you say the rent is and the $600 that he says the rent is. Till I know what's going on, you're going to pay $685 to this court, and this is how you're going to be doing it.
He's not going to like that.
Let's see.
These people need some basic civics classes on how
So
courts
we
work,
are
how the
going
law
to,
works.
oops.
Does he understand escrow? Yeah, she's not getting a
All
chair
right.
from
So what we're going to do is we're going to prorate that $685 for December. So we got 14 days.
That was the last month, not this month.
So it's about $22.10 a day. You got 14 left. So you're going to pay $309.40 into escrow at this court. And you're going to be paying that for prorated rent from today's date to the end of December. This is not Burger King. People do not get to. And you'll have 7 days to get that to us. Then the $685 will be due on January 1st. So since we're not open January 1st, I believe we're open. Have we opened the second? We're open the second hour. We're not here.
Fourth Saturday.
Oh, okay. So it'll be January 5th that you'll pay. January 5th, the next business day.
Why can't it just be 600?
Sir, because I don't know anything about what you're saying, if it's true, and I don't know what she's saying is true. Sir, listen, I've made my decision. Quit disputing me. It is done. 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 And if you keep talking, I told you what's going to happen. And that's a fair amount. We're going to see everybody back here. You're going to receive this escrow order via email, because it's going electronically. It's going to come to you. You got 7 days from today's date, sir, to pay the $309.40. And then you'll come back and pay the full month rent on January the 5th. And that's what we're going to do today. And if the case gets dismissed, you'll get that money back. We will mail it back to you. If you choose not to dismiss the case, then we're going to deal with it at the trial. And whoever wins is going to get that money. So you may get it back if I determine you don't owe anything, or she may get some of that money, depending on if I determine that she's owed rent and what amount. Yes. Where's the dismissal?
Don't have any.
Okay. In the interest of just time here, I'm going to print it out.
The judge.
And why don't we have
to
any
charge for the legal advice she's
They
giving?
want everything online.
I know, but we need to have one or two. So.
Keep an eye on a couple of courts. I know Minecraft Court is operating today. They're between sessions right now. We're gonna watch to see if we
Okay,
get
I am
anything there.
going to print this form, and somebody just went to go get it.
I wouldn't mind heading back into the Texas court we saw yesterday with that fiery
And we'll
young
give
judge.
each one of you a
She's a
dismissal form.
firecracker. Need to find that court again. I don't remember which one it was. Travis County, right? Something in Travis County, Texas. Judge Sylvia
Can I ask a
Holmes.
question?
Yes, sir.
How can I go about protecting myself because
Find a lawyer.
why would you just
Find a lawyer. My job is to be neutral and to make a determination on the issues before me. It is not to give legal advice. I give you some procedural advice on how things go, but I'm not giving you any legal advice because that's not my role. You got a lawyer here, you got a lawyer here, you got lawyers all around here, and you got legal aid. Right there. Right. I can't tell you that. Hit that yellow form. The number, same number I gave to her. Lakeshore Legal Aid. And you have to call them and see if you're eligible. You both have a copy of a dismissal form. If you look in the center where it says stipulation, you're going to fill out the case number and name and everything at the top. You're going to go down to stipulation to dismiss. You're both going to sign a stipulation. You'll submit it. You can come down here. We'll scan it in for you. And then they'll submit it to me online and I will sign it. That will dismiss the case. Then she can proceed if she wants to on the other kind of case. So does that answer everybody's questions? Because if not, I'm done anyway. Okay. So we'll see you back here on January.
receiving the email about what I'll be paying for the proration fee and everything?
You're going to get this order. I'm working on it now.
Okay.
You're going to get it order, and you got 7 days from today's date to get it in.
Okay, Judge Holmes is also doing
You're all set.
eviction stuff today.
Good luck. See you next year.
We see you next year. We're going to jump to her next. She's a fiery judge out of Texas. We saw her first time yesterday. She is a piece of work. Loved watching her in action. Let's see what happens today.
Here and the billing rate. I see the attorney sheet, so thank you for that. I would set the appeal bond equal to 1 month of rent. So the appeal bond will be just $17.69, the same as the monthly rent. All right.
Thank you, Your Honor.
And if there's no questions, all parties are excused.
Why did she remind me of
Thank
Billie
you.
Eilish?
Thank you.
Good luck to everyone.
She's the Billie Eilish judge from now on. Hope she doesn't mind that reference.
Next cause will be 251720. That's CLPF Lantana Ridge versus Kenneth Egwu and other occupants in number 1736. On behalf of Lantana,
Robin Shelton.
and do I have someone on behalf of Kenneth Egwu?
Yeah, Kenneth, this is me. I'm here.
Good morning, sir. Thank you for being with us.
Thanks.
All right, Ms. Shelton, please tell me about this case.
Yes, Your Honor. This case is for non-payment of rent. The monthly rent is $1,051. The defendant has been behind since 11 of 25, and a notice to vacate was sent 11/12 of 25
Wow,
for
they
his
don't mess
first
around.
class and certified mail. Today, we're seeking November's rent, December prorate through today, for a total of $1,977.39.
Any subsidy on the rent?
No.
All right. Good morning, Mr. Egwu. Thank you for being with us. Ms. Shelton is here. She's told me the case is one about non-payment. So the first question I would ask is it correct that under the lease, the monthly rent is $1,051? Is there a highlighted?
Yeah, that's accurate. That's accurate. I'm here.
Okay.
How much?
Wait till you know you're on mute.
Could y'all?
Thank you.
Can I? How much was owed till today? She said 1,009.
1,900.
77.
I mean, I could pay that. It's just that I'm like probably like $100. No, not even 100. I'm like, if I can share my screen, I can show you the exact amount that I have right now.
That's not necessary. Please, that's not what. Here's the thing, Mr. Egwu. Ms. Shelton is asking for rent
share
through
your bank
today.
account.
You absolutely can contact your landlord and see if they would be willing to work with you or negotiate in something. I'll say that legally under the lease, you owe 1051 times 2 because you owed for November and December, and you may also have late fees in that. In court, the law only allows a landlord to seek the rent. And our landlords here have worked with me for years, so they only ask me to prorate through the day of the hearing, which I've never objected to, right? We don't have to get into anything. So the number that we're giving in court today may very well be a smaller number than the landlord wants you to pay. But you can contact them immediately and
yeah, I'll do that. I need to do that. It's not that I don't want to pay. It's just I don't have,
That I understand. I have no doubt that if you had the money, we would not be here. I rarely find a situation in which someone's, sort of refusing to pay, but has the ability. So I appreciate that, sir. All right, then today, then let me give you some final numbers. And then with that, you can begin, like I said, contact the landlord or any services and let them know if there's something to be had.
Yes, ma'am.
Okay, the judgment today will be for $1977, and that is just for November's rent and December, 18 days of December. There's no late fees included in that. The only extra money that the court would put down as being owed is the filing fees that the landlord pays. So again, about $130 or so. Either party can appeal. I'll put the appeal bond equal to 1 month of rent, so that will be $1051. Mr. Agnew, we'll email you and Ms. Shelton both a copy of the order along with information about appeal. Tomorrow is day 1 of that 5-day deadline. All right, sir.
All right. Thank you.
Hey, very best of luck to you, sir. Thank you.
Yes,
You're
ma'am.
all excused. And Ms. Sheldon, thank you as well. If you have no other matters, you're all excused.
Landlord
Thank
tenant
you,
is my
Judge, and
favorite.
happy holidays to you.
Happy holidays
you.
to you too.
You're
We'll
welcome.
come back to her later.
Our next case is 25-1711.
We're going to go to Judge Simpson. Where's Judge Simpson?
Where'd he go? He was just. What?
He's going to do probable cause conferences. PCC's a little more spicy than landlord-tenant stuff.
Hello, Judge Simpson. Hello, sir.
Assistant Public Defender Davey Lebo on behalf of Mr. Frost, who stands to my right.
Your name, sir?
Carlton Dion Cross.
All right.
And Your Honor,
Requesting an adjournment?
yes, Your Honor, I have some mitigation information I'd like to present to the prosecution.
Probable cause conference, January 8th, 2026, 9 a.m. Bond will continue. Thank you, sir. Thanks, sir. Have a good holiday. You do the same. Thank you. Court calls the cases of the people versus John Hart.
Assistant Public Defender Davey Lebo on behalf of Mr. Hart, who stands to my right. Mr. Hart, could you tell the court your name?
John Joseph Hart. Thank you.
And Your Honor, we're still working on a plea offer in this matter. I would ask for an adjournment.
I'll go over here.
You think you can get progress toward it by the 30th, or do you need till the 8th?
That would depend on the prosecution's position, but I have no reason to believe we can't make progress by the 30th.
Oh, he has something to say.
This is the first time I've been made aware that we're even negotiating. Oh, no. How exciting.
I didn't even know we were negotiating.
Are you, is he held on anything else?
He is, Your Honor. Your Honor, he's expecting to be released on the 19th. He's being held on a matter in the 15th District Court where he can be released upon completion of Beyond Barriers, which he's indicating to the
Got it.
He's holding Beyond Barriers.
But when you say the 19th of what?
January, Your Honor.
Okay, so let me do this so that everybody can get what they need to get together. I'll adjourn this out to January 8th, 2026, 9 a.m. on all these cases so they can have fruitful conversations.
Your Honor, that's why I brought the book to let you know I'm making progress. You know, I am making progress.
I don't doubt that you are. I had faith in you that you would do it when sometimes people have to be sat down.
Yeah, Judge Valvo ordered it, and I'm glad she did. It's a great class.
Great. Fantastic.
Wonderful.
All right. Thank you.
Got all the colors. They've got the red and the
Court
yellow.
calls case people versus Juwan Daniels.
Assistant Public Defender Sandra White on behalf of Juwan Daniels.
Hands out of the pocket. What you got there, sir?
What's your name, sir?
Juwan Daniels.
I'm asking for an adjournment. At this time, the prosecutor has not extended an offer, so I want to submit some information to try to hopefully get some negotiations started.
See if we can.
Gonna solicit an offer. What are we looking at here?
Probable cause conference in this case, I'll adjourn January 8th, 2026, 9 a.m. Bond will.
Judge, can you call Jesselyn Gray?
Thank you, sir.
So that we'll put everyone back where we belong. And
Court calls case of the people versus Trevor Howard.
Alexander on behalf of people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Howard, who's approaching judge.
Did they get a memo about the closed?
Thank you.
Your Honor, we're asking for an exam in this matter.
All right. Discovery is complete.
To the best of my knowledge.
People have their witnesses available the 30th.
We'll do our best.
Preliminary examination in person, December 30th, 2025 at 12 noon. That's before me.
Thank you, Judge.
Bond will continue. Thank you. Court does call the case, People versus Charles Lee Davis II.
The second.
People.
Was
Brian Bowling on behalf of Mr. Davis, who should be on Zoom, Judge.
Mr. Davis, thank you for being
Mr. Davis, can you state your name for the record, please?
Go up here.
Charles Davis.
Thank you, sir.
Your Honor, I'm asking that this matter be set for an exam. To my knowledge.
Discovery is complete.
To my knowledge, it is.
People have their witnesses available the 30th.
We can track for that date, Your Honor. Thank you.
Preliminary examination in person, December 30th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue. Thank you, sir. That is an in-person proceeding. Court does call the case of the People versus Jermaine Johnson. Just tell her no.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson. Mr. Johnson, will you state your name for the record?
Jermaine Lamont Johnson.
Thank you, sir.
Your Honor, we are asking for an adjournment. We have, I believe, reached an agreement that was proposed this morning, so I'd ask for a brief adjournment so I can discuss that with my client. I did prepare an order for release to treatment. I believe the court, if the
I do have that. I will sign off on that order so we can get that out of the way. Probable cause conference, I'll adjourn this to December 30th, 2025, 9 a.m.
Thank you. And Your Honor, I believe that he needs to be arraigned on a amended count 2 on 5805.
Just adding a misdemeanor count over this.
Which case is that on? I got it. Okay, as to the arraignment on count 2, the open and taxing a motor vehicle.
Your Honor, we'll waive reading. My client will stand mute.
All right.
Acknowledge receipt.
And then stood mute to count 2. Court will enter a not guilty plea.
This courtroom is hopping today.
Changing your bond condition. So these matters then are adjourned to December 30th, 2025, 9 a.m. Both matters.
You get to treatment.
Oh, got it. That's on the consistent with the order.
Yes.
Oh, gotcha.
Yes.
Okay. All right, we're all set. Thank you.
Okay.
All
right.
Ketchup and mustard restored to their proper places, one of each.
Court calls case People versus Robert Dolan.
Assistant Public Defender Sandra White on behalf of Robert Dolan.
Who was
Make his way to the court.
slowly making his way.
Oh, Mr. Allen.
Putting on his glasses. Got his papers.
Your name, sir?
Robert Dolan.
Alan.
Yeah, I'm asking for an adjournment in this matter. I do need to see if there's more discovery I need to request from the people, but also negotiations and to review some discovery with Mr. Dolan.
Probable cause conference will be adjourned January 8th, 2026, 9 a.m. Bond continued. Thank you, sir. Court calls case of the People versus Sandra Law.
Ask the fellows for the people.
On behalf of Ms. Law. Ms. Law, could you please state your name for the record? Sandra Law.
Thank you.
And Your Honor, we are requesting an adjournment. A part of this is she needs to get into treatment so that I can try to negotiate this offer. You did sign an order for treatment. She was actually supposed to be released to treatment this week. Judge Washington changed some of the parameters for the release for treatment. And so.
What's that mean?
Well, the treatment facility she was going to was a shorter term than the one Judge Washington wants her in.
Got it.
And so we're trying to get her into treatment. In the meantime, I did email a request for the offer here. So we're just asking for adjournment so she can get into treatment. She still also wanted me to let you know she still has the concern regarding being evicted. I told her that I would check with the court to make sure there's no evictions in process. The last time I checked, I didn't see one.
We can get to 1,001 likes.
What was her?
What's your daughter's name?
I think the court, we were here last week and Ms. Law was concerned about, couldn't find out any current eviction case. The court was found one that had been dismissed.
Yes, that is correct. What is your daughter's name?
It's Sandy Sherman versus Thomas Berry.
Pardon?
Thomas Berry is the landlord.
Berry.
You're looking for any case, correct?
Right.
Serenity Sherman was.
Yes.
So I do have a case being filed on the 26th at 8:35.
It does.
Yeah.
Okay. So
she is
okay.
just.
Is that? Can you tell if that's an NPR?
According to the JIS determination.
Ew. Okay. You don't know what that means. So NPR would be a non-payment of rent case. Termination at some other reason for terminating tenancy, whether it be expiration of lease, a violation of the condition, something along those lines. That it's not about money. I guess the best way to put it.
Okay.
So typically, I'm just going to time this out. You said that was on the 26th.
Yes, sir.
I'm here on the 2nd.
No, sir.
I'm not. Okay. So here's what I'll do. We won't know anything. Typically in those cases, what happens is the first date is an adjourned date so that they can get counseled or do whatever, or seek assistance, the like. From the 26th, since I'm not available on the 2nd, the next date that case would be set, as long as somebody shows up and it's not a default, would be the 9th. Okay, so nothing is going to happen until that point. Let's just, so I know it doesn't help your worries necessarily any, but just play that out, that if on the 9th, the worst case scenario that a judgment was entered that day, the earliest that anything could happen would be the 19th of January.
So can we maybe, Judge, I know you gave me the 8th before. Can we look at the 8th to make sure she's in treatment and maybe?
Yeah, that's what I was going to do. I was going to set it for the 8th, but I know she was worried about that. I just wanted to give her an estimate as to what we were looking at. So probable cause conference, January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Is that in her daughter's name, the case?
Yes.
Okay.
Yes, Your Honor.
It's all occupants, so and I live there with her. She's only 21 years old.
Right, but the name on the case is her daughter's.
Yeah, it's Miss Sermon.
Got it. Okay. Pardon? Yeah, I get it. Or calls the case of the People versus Grant. Garcia.
Ashley Phelps for the People.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Ducia. Your Honor, I have not been able to have any contact with him. My understanding is that he had court yesterday before you, and he failed to appear. There was communication that he was in the hospital. He did not issue a warrant on that matter.
I didn't?
You did not, Your Honor.
Really?
I'm filling in.
Really? What's going on?
Christmas spirit.
What? No, couldn't have been that. What happened?
He had been hospitalized and then gotten out of the hospital and then had gone back in the hospital.
Right, so I did see that communication.
Yes, the court said to Ms. Perrine to provide the proof, even though we didn't have it yesterday, and that's something I requested. And the court indicated it was likely to adjourn today's hearing as well.
Wow. People pay attention to what I say.
I really do.
So all sounds great.
So, gee, what day did we put that up? We put that to the 7th, I bet.
Different.
Yes, we did.
I think so.
54A.
So probably-
Felony court.
No, I don't. Did you see it yesterday? I put that out to the 7th.
I have the 21st.
Really? What was I thinking?
All of those dates sound great for me, Judge.
21st of this month?
No, of January, Your Honor.
Oh, I went, okay, I was gonna say. Wow, yeah. Okay.
That's not how you said it.
Adjourn this out January 22nd.
All right. That wraps that one up. Let's jump to
Thank you,
felony court.
Judge.
In progress.
Oh, I must have.
Judge Stacia Buchanan here.
Deterrence of others in the community from violating court orders, for protection of Ms. Shannon, and for purposes of you receiving a consequence for what you've done, you are sentenced to 21 days jail for the bond violation. And then you will return to bond at that point, assuming the case is still ongoing with all the prior conditions. Since I gave you jail, you do have the right to appeal that sentence. If you need a public defender to assist you, you need to make your application within 14 days. Now we need to wrap up the preliminary exam. My understanding, we set this over for argument today. Mr. Marchmina, your argument and bind over.
Yes, Your Honor. Now, obviously, the only felony charge at this time is first-degree home invasion. We're not going to be proceeding on that one. To cut to the chase, I'm going to be asking to add 2 counts: assault with intent to do great bodily harm less than the crime of murder, and assault with a dangerous weapon. Now, before I get into the elements, I do want to talk about, it is the people's position that he did use a weapon in this assault, and I do want to refer the court back to some of the exhibits. Still extending.
Judge Brantley Clark's also doing felony hearings down in Florida, so we might jump to him as well. Why are we showing somebody's? I like to see their desktop. It's much cleaner than mine.
First, I'll refer the court to Exhibit 1B.
You know what? We're going to have to jump. We're going to have to jump. I'm sorry. Going to 8. Some of these pictures.
I don't know why I keep having this issue.
All right. Sorry, content warning. I could see some of the thumbnails, and I
also got Roselle Payton, but I don't want to call him just yet, Your Honor. And one more. I'll hold off on both of those. I'll be back.
Charles, you want to sign me?
You what?
Hush,
Sure.
hush.
I'm trying to have court. Don't raise your
Yes, that's the guy. Here we go. Let me get the better
Wait,
audio.
before Mr. Murphy sits down, let's go ahead and call him. Ms. Peskin's waiting.
Okay, here we go. Better audio. I might have to move to the top corner on this one because the judge's view puts me right on top of the defendant. Judge, can I stay up here with you? Is that all right? I believe this is Judge Clark here is in Florida, I think in the Panhandle area, if not mistaken.
Judge, we just completed depositions in this case, so it can be put on a trial calendar.
All right. Mr. Sullivan, when you want to set this for trial, Ms. Peskin?
March or April, Your Honor.
All right, let's set it for March 2nd, since this is an older case, at 9 o'clock, at 8:30, and then we'll set it for January 22nd at 9 o'clock for trial manager.
Thank you, Judge.
Okay? Thank you.
Waiting for somebody to talk in court. Jean, PD assistant. Assistant. Is that French?
Meredith?
Bellinger?
Point to the defendant of your choice. He'll come down and you can argue the case in front of the judge. Just orange.
Judge, this is Tristan Bellinger. There's two cases with Mr. Sullivan. We weren't able to get the victim served, so we're trying to reschedule that. If we could have the February 19th return date. He also has a VOP in Washington County.
All right.
Judge, he had asked, there were, I want to say it's 3 counts that were not filed on. And we'd asked that he be ROR'd on those. He still would have a $50,000 bond on one, and I can't remember what the other one was.
Isn't this close to Brandy Churchville?
Cases were not filed on.
Okay.
I thought this was in her neck of the woods.
And Oliver Moore.
Jury box is full of inmates.
Oliver Moore.
In custody.
Judge, the complaining witness in this case has sent me an email, done a notarized statement, but she did not show for her deposition last week.
We couldn't find her, right?
That's right. She was.
Yeah.
She may have been evicted.
She was evicted from her, right.
But I actually had Mr. Jordan and them out looking for her.
I see a big bottle of hand cleaner.
Have you not be able to find her at this time?
I've spoken to her a few times. I think we know where she is. Okay. I think her views are clear on what she would like to see happen in this case. I am just not in agreement, and we're working with Mr. Meredith to find a proper resolution here.
You think you'll have anything by when?
January
22nd at 9 o'clock.
And if we get something worked out before then, I'll get him brought back.
Advancing on any kind of early docket you can get it on.
I got one I can call.
Yes, sir.
Mr. Bowden, Devon Bowden. Case number 252223. That's you, Mr. Bowden, isn't it?
I like these attorneys' chairs. They look super comfy.
Mr. Wilson?
Yes, Your Honor. As the court may be aware, I was just recently assigned to Mr. Bowden's case. I haven't had a chance to talk to him about how
we got to talk about. There ain't nothing we got to talk about. You don't represent me. I represent myself.
No, sir, you don't. Mr. Wilson represents you. That's enough.
He don't represent me. I represent me. No, you don't. You don't make the rules. This law that you got to go by. You ain't hold. You did not even hold.
Y'all go ahead and take Mr. Bowden out. Hearing's over with.
Yeah, you got me fucked up.
Yeah. Y'all go ahead and take him out.
I'm going to set up a trial, Your Honor.
That's all right with me, Your Honor. I can get the.
So I'm setting it for trial right now. We'll set it for March the 2nd at 8:30. February the.
I can have it ready to go by then.
February 19th at 9 o'clock.
That'll be a fun one.
Put March 2nd, Your Honor.
Yeah, March 2nd. I don't know. I'm not going to do it on my own. I don't know if he needs to be examined or not. I got no idea. I don't know that it would do any good. That's up to you. I haven't seen anything.
Yeah, I believe by March, Ms. McCarthy will be back here, but I may at least set it second chair. We did conference on this. I don't think just because Mr. Bowden is crude, that's a conflict.
Yeah.
For what it's worth, Mr. Bowden also sent me a letter calling me that, and I actually framed it and have it hanging in my office.
He sent my boss a letter that I'm not even going to start.
Yeah.
You're not the only one.
Can we subpoena those letters? Can we FOIA them?
All right.
Apparently he's a letter writer.
Mr. Meredith?
Mr. Bird.
Mr. Bird?
Lots of people in court. Judge Clark doesn't put up with crap, as you saw.
Yeah, we have depositions January, but he's on tomorrow's docket for a bond reduction.
Okay.
Tomorrow, speak on that. Thank you.
All right. We'll see you tomorrow morning.
See you in the morning.
Thank you.
See you in the morning. We did watch a court here with Judge Brantley Clark, a court case where a defendant went pro se in a possession charge where he had cocaine in his pocket, and he won in a jury trial. It was epic. I think it was against that lawyer who was walking around there, strutting his stuff in the top right-hand corner. That said he framed the letter. That was the prosecutor, I think.
You're not kidding. Madam Clerk, is there any reason we couldn't move our afternoon docket to tomorrow morning? It looks like they're all local counsel. This trial management, this out of custody trial management. Well, yeah, Ms. Nelson, if you can hear.
You trying to get the day off for some
All right,
golf
well,
or
let's just,
something, Judge?
let's talk to, but it's Matt, Russ, Michelle Law Smallwood, Mr. Peacock, Mr. Shepherd, Ms. Bennett, Mr. Downing. So I don't know why we couldn't do it tomorrow morning. Because we've only got 36 set on the docket for tomorrow. Yeah. Yeah, I'm gonna tell them right now, we got hey, Mr. Counsel, everybody. Any reason we can't move our afternoon docket tomorrow afternoon to tomorrow morning?
I've got no objections. I won't be here.
Anticipating on what I'd like to do. That's why that's one what?
A Williams rule hearing.
Not tomorrow afternoon, we're not.
Well, that's fine.
I said, I've got something that it's come up that I got to do.
We will just have to make sure she comes in the morning, and I ask you that you do it at the end.
I'll do it the last one, but
we have to make sure she comes in the morning.
Williams rules where they ask the judge to allow evidence of a defendant's other crimes to prove motive, intent, identity.
Can you get her? Is that Mr. Butts?
For the current charge.
Can we get her here in the morning?
We will do our best.
Because I
understand.
We have to reschedule it if we can't do it. This is too long a week for me to do a Williams rule at 1:30 on Friday afternoon. I won't be able to.
Nope, not going to happen.
Being honest with you.
The judge just got that tea time he was wanting, and everything has to move. No, I don't know what it is, but he's got something urgent that's come up. So, afternoon off. All right, Minecraft Court is still not doing anything, but we're keeping an eye on that one in case something happens. Judge Simpson's court is still going on, but they've got me in the wrong corner for that. I mean,
that charge, I have the sufficient basis in which I could determine that what you're telling me that you're guilty of a crime.
Well, I remember that it was outside.
Oh, okay, we got that, but
Would like me to send the police report?
here's what I'm going to do, sir. I'm going to have them take you back and we'll bring you out again. But I just wanted to say this to you. Would you like to change your plea to a no contest plea? What will happen at that point is I will review the police report in this case. From that police report, I'll make a determination of whether or not there's a factual basis to justify the offenses that you're pleading to.
Fair enough.
Okay, you have a problem with that?
That's fine.
Okay, so what I would need for you to do, and so the two things I'd have to explain to you, it's the same thing, and that is that it means that you're not wanting or contesting those two charges. You get that?
Yes, sir.
All right. The second thing is that when Judge Barr sentenced you, sentences you, he's going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. So to the charge of larceny less than $200, how do you now plead?
No contest.
And to the charge of attempted resisting and obstructing, how do you now plead?
No contest.
All right, very good. And so now here's where I'm going to have to then send you back. I'm going to have to get the report. I got to review it. We'll bring you back out and hopefully we can finish this.
For the record, Your Honor, there are two separate reports. So you're going to get two reports, but they're both pretty short.
Good enough. All right, that's fine.
I'll see you just.
All right.
He was the hospital bed guy.
Court calls case People versus Marshawn Smith.
Oh, that's him, Marshawn Smith.
Pardon? He's in.
That's me.
Okay.
I'm right here, Your Honor.
I got you.
Does appear to be in the
Mike
hospital.
Gaddy, Assistant Public Defender on behalf of Mr. Smith.
Yes, he's here. Jefferson. What are we doing?
Your Honor, I am asking for a brief adjournment so that I can talk, so that we can speak with Mr. Smith in some more detail. We were able to talk to him yesterday via phone, but it wasn't optimal.
We need more time there.
I do have a green sheet if I may.
All right. Did you want the 30th or the 8th?
Let's do the 30th, Judge, if it's available, and if I could be heard on bond.
Yes. So probable cause conference will be adjourned December 30th, 2025, 9 a.m. As to bond.
Your Honor, like I said, this is a situation where the police were called for a civil standby. Mr. Smith is here via Zoom. He does have stable housing. We can give the court that address. He's not a flight risk. It is in the area. He's gainfully employed and has been so for the last year and a half at the Toyota facility in Saline. He's got a strong support system. So I don't think he's going to be a flight risk. I think he would appear at all court dates. Moving forward, he would comply with any conditions, as is any conditions that the court would deem fit to assure that there is.
When you tell me it arose out of a civil standby, what do you mean?
The police were there for a civil standby, and I believe that he may have been the one to call them. I believe there was a case pending for us, and he asked for a civil standby, is my understanding from the report.
He asked for a civil standby, goes there, and then new charges for whatever reason arise.
If I may, Your Honor.
I don't think you want to.
Okay, I'm sorry. I'll keep mute.
I'll keep mute.
Yes.
Listen to your lawyer.
Obviously, ultimately, he did end up being charged in this matter.
Responding to people.
That's one way to read the report. I would give the police were called because the defendant who had been released from jail was back at the victim's residence. A civil standby would have been maybe a more proper way to do it when deputies made contact with Mr. Smith to cooperate. And I could go into his criminal history, which is.
That's
so
fine.
he called the cops when they showed up. He went to Iran.
I get the picture. Defendant's motion for any type of bond reduction in this case is denied at this time. Bond will continue.
Thank you, Your Honor. And just for make sure, I took December 30th is the date, correct?
December 30th.
Thank you.
9 a.m. All right. Thank you, sir. Court does call the case. People versus Brandon Thomas.
Assistant Public Defender Chelsea Virgils with and on behalf of Brandon Thomas. Please state your name.
Brandon Thomas. How you doing? I'm doing well. Thank you for asking.
Your Honor, we're asking for an adjournment and I am asking to address bond.
Of course you are. How much time did you need for an adjournment? The 30th? Will that work for you?
That's fine, Your Honor, yes.
All right. Probable cause conference will be adjourned December 30th, 2025, 9 a.m.
And about
Your Honor,
bond.
Mr. Thomas is in custody after a bond violation. Missed tests was the issue. Mr. Thomas was previously living with his parents and his 7-year-old child with special needs. His parents got evicted. It was a very tough time where he and his mother both lost their jobs. I believe that the failure to test was a financial issue. However, he does have a job lined up for when he's released and definitely plans to test if you allow him to. He recently finished a 10-week outpatient program. The whole time he was doing that, he was testing. Every test was negative. He reports he's been sober since the alleged incident in this case. He and his family live in Ypsilanti. I don't believe he's a flight risk and would greatly appreciate another chance to comply with bond.
He lives in Ypsilanti?
I believe so. Is that correct?
Yes, Your Honor. Well, you were testing for 35th District Court at onsite. Yes, sir.
He's on probation there.
Right. But our problem that we had is that when he was here the last time is that he had not tested at onsite since like early November.
That's correct, Your Honor. I believe there was a period of about a month where he did not test, but again, I believe it was a financial issue and his family and his own finances would be more stable.
I understand what you're telling me on that, but how am I going to get him to test now if that issue hasn't changed, right?
With the financial issue?
Yeah. I'm hearing you saying that he didn't test because of financial issue, and I understand all of that. But now you're telling me that he can test, and I don't.
So, Your Honor, with the financial issue that we had and getting evicted, we just got ourselves into a new home, and my father is the breadwinner, and he's a basketball coach, so he's had a hectic week himself. He had 3 games this week. He just had a game yesterday as well, and me being just myself, it was hard for me to come to him with all the things that he had going on and all the finances that he was paying for me to like a 30-year-old son to be like, Dad, can you keep giving me this money? But moving forward, he said he would help me now that we have our new house and getting things together. So I'd appreciate it if you would let me test if he.
Have you been able to verify any of that?
Yes, sir.
No.
I have not verified that, but my main point is that at the time when he stopped testing, he and his mom had just lost their jobs.
No, I get what you're saying, but he's telling. So I get that part of it. I mean, I know I look stupid, but I'm not really. I get that part of it. But now you're telling me he can test, and I was asking, why can he now do it?
Because we're in our.
Just hold on.
Oh, I'm sorry.
And I heard you. I heard what you said to me.
I'm sorry.
I then asked, as he's telling me all of this, have you verified any of what he's telling me regarding the new house, Father, those things?
No, I do not have independent verification of that.
All right.
Which they are here right now as well.
What do you mean?
My parents, they're outside.
Outside where?
Getting the car and all my belongings from the courthouse. So if that was possible, he could.
How do you know? So they're not in the courtroom?
No, sir. He didn't want to see me like this in shackles and chains.
I can get that.
But they're here to support them.
And the new place is in Ypsilanti?
It's in Canton, Michigan.
Judge is thinking. Okay, Minecraft court is about to start. We might bail on this for a minute while the judge thinks. Here's what we have right now.
All right, Ms.
Minecraft
Ferguson.
court just disappeared. Not sure why.
Yes, ma'am.
Turn off Judge Boyd for a minute. So Judge Clark.
2025.
Oh, let's
The
go to
one
7.
count
Let's
is
go to 7.
theft
Here we go.
felony of the 5th degree in violation of revised code 2913.02A1. It is the state's understanding that today the defendant would like to withdraw her previously entered plea of not guilty and plead guilty to this one count, and there is no agreement as to sentencing.
Okay. Smith?
Thank you, Your Honor. My understanding of what's to occur is consistent with that which was outlined by the state. I do believe that Ms. Moore will be entering her
I'm not even sure why I'm doing this, but I'll do it.
There was some.
Here's
what you're telling me doesn't make entire sense, but I don't think it's a lie. So I'm going to grant you a personal recognizance $25,000 bond. You're to test 2 times per week at community corrections, nowhere else. All right, up here.
Yes, Your Honor.
I'm not going to hear any excuse I don't have a ride. I'm not going to hear any excuse I don't have money. I'm not going to hear any of that. You don't show up for the testing or you don't show up at court, we're coming to get you.
Yes, Your Honor.
Am I clear?
You are clear.
I said it for the 30th.
Up here for testing.
Right today?
Yes.
Okay.
Thank you.
Thank you, Your Honor.
Now we go back to Minecraft.
No, I'm kidding. Go. Just go.
Back to Minecraft. Here.
Alville.
What's that for?
Medications that I have taken.
Your Honor, for the court's awareness, the Percocet is prescribed. Ms. Moore has a torn rotator cuff.
All right. Do those medications, when did you last take them?
I'm taking them now, every day.
Did you take it today?
Uh-huh.
Does it affect your ability to understand what's going on here?
I understand.
Okay. Did you get a copy of this indictment, this charge?
No.
Back at the beginning of the case, the paper that says what you're charged with.
Oh, yeah. That's how today.
Do you have any questions about it?
No, sir.
All right. Now,
Excuse me, I got a cold.
is it true you're going to plead guilty to this charge today?
Yes.
All right. Before I accept your guilty plea, I need to determine that you know and you understand the constitutional rights that you have and that you'll be waiving, the consequences of the guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Ms. Smith a little bit more, let me know that and I'll give you more time. Do you understand that?
Mm-hmm.
So I'm going to go over each of your rights, ask if you understand them, and then ask if you're going to waive those rights, okay?
Okay.
All right, you have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After those witnesses are done testifying for the prosecutor, then you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses
Thought it
come
was
here
gonna
and
be more
testify
spicy than
for
this.
you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, then I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
Yes,
Okay.
sir.
You have the right to testify at a trial if you want to. Do you understand that right?
Sorry, we're going to go back out
Are you waiving
to
that right?
Judge
Yes, sir.
You have the
Wade,
constitutional
maybe?
right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody could comment on that decision. Do you understand that?
Yes, sir.
Okay, we're going to Judge Boyd.
No problem. And I'm sorry, what page is SOPS on?
On page 14.
Thank you.
Fourth one down.
I'll fix the audio here in just a second.
All right, counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Sobbs, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Sobbs, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Ms. Sobbs, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 12 months in the state jail facility. There's a $1,500 fine, and the state is opposed to your application. Did you understand that to be the plea?
What?
All right, according to your plea bargain agreement, the state is asking that you be sentenced no more than 12 years in the state jail facility. Do you understand?
Yes, ma'am.
They are asking that your fine be $1,500. Do you understand?
Yes,
They don't want you to have probation. Do you understand?
ma'am. I have to say so.
Now, here's the thing. Now is not the time to say anything. Now's the time to just answer the questions that I'm asking of you. Do you understand that the state is asking that you be sentenced anywhere from 180 days up to 1 year in the state jail facility? Do you understand?
Yes.
Do you understand that they're asking that your fine be assessed at $1,500? Do you understand that they don't want you to have probation? They want you sentenced to time at the state jail facility. Do you understand? Do you understand that to be your plea?
That they want me, yes.
Defense is at the plea?
It is the plea.
State is at the plea? State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There have not.
Then how do you plea? Okay, why is everybody whispering today? I need everybody to speak up. All right, state, any evidence?
State offers states one attachment.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Counsel, if you would like this set for a PSI, then it'll be 8 to 12 weeks.
That's
all right. I need a PSI date. All right, I'll get Vashon, what date for a PSI? Oh, just give me a date that you would like and we'll make it happen.
May I have February 5th, Judge?
All right, we'll be back on February 5th.
Very good. Thank you, Your
All
Honor.
right, thank you. Oh, counsel, is there a need for a mental health evaluation? All right, thank you.
Is it for Pearson infected?
Yes.
There's a heated appeal argument going on in front of the three-panel appellate board.
Who's here on Jonathan Carter? She's not on Zoom.
No. Case number is it? Is it on today's topic that we want to able?
Anyone else ready?
Yeah, I'm sorry. Mr. Singh. No, I gave you
They're not ready on Carter.
Gotcha.
Ready.
Page 14, second from the bottom. Michael Evans.
If they're not ready, Judge, we're gonna go to
Michael Herrera.
Present, Judge.
Come forward. All right, it has.
Who's that on?
Oh, I pulled up the wrong one.
Thank you. Can you have finances? I'll try to get hold of the.
All right, today is your plea deadline date.
Yes, ma'am.
So have you all reached an agreement or you want a jury trial?
We're gonna need a jury trial, Judge.
How long do you expect this trial to last?
2 days.
He's from that.
All right, I need a jury trial date, 2 days. Is this criminal trial division or family violence?
Family violence.
On page 14.
Norman, can you set this for the first week in January?
Judge, I don't know that I'll have enough time to prepare. I'm gonna need to get an investigator.
Okay, well, we'll see where we are.
I can do January 7th, Judge.
All right, January 7th.
Thank
Once
you,
you
Judge.
sign the reset form, you will be excused. And I need an acknowledgement of discovery done, please.
Yes.
And this is family violence.
Can we sign? Judge,
Yes.
sorry. The co-defendant is Mr. Herrera's wife, who is also on your docket. So
Yes.
just wanted to let you know, some consistency in the court dates might help.
Oh, no, it's going to be the same, but nothing can be done until their attorney shows.
I understand.
Yeah.
I just want to let you know.
Okay, all right, thank you.
Thank you.
All right, thank you.
Thank you.
Not
Yes.
acknowledgement of discovery.
Then highlighting the
except for
fact
trial on
that
January
did
7th.
testify.
Trial?
Yes.
Okay.
All right, Jonathan Tavares Carter. Come forward.
Just looking at the court's Judge Simpson's
Yes.
sidebar.
I apologize. Just if we could have like a few more moments. The complainant had to go to the bathroom real quick, but she should be back.
I mean, she's just going to give victim impact, or is she giving testimony for this?
She wanted to see and take responsibility.
All righty.
She left like a few minutes ago, so it didn't be too much longer.
Okay. All right. Thank you. All right. Just have a seat.
Have a seat. We might jump down here to this
Anyone
argument
else?
in Arizona. Listen to this.
Now, the question then is, was this a adverse statement? Or was it something like in
This is an
Mata,
appellate
where
argument.
it was an inadvertent mention of the word testifying, which is what happens in Mata in closing. He says, defendant testified, I'm sorry, his conversation with detective. And then there was an immediate corrective instruction. That's the type of end of the spectrum extreme that this is not meant as a penalty. It's not a constitutional violation. The other end of the spectrum is, he didn't testify, you have to find him guilty because he didn't testify. That is not what happened here. But what she said is, he didn't testify, she did. And putting it in juxtaposition with one another is much closer to this end of the spectrum, where she's saying, this bears on guilt, this bears on innocence. It's also closely related to the issue in Murray that was brought up in rebuttal closing, when the prosecutor made the argument about the burden of proof. If you're back there talking about, oh, like maybe he's guilty, well, why are you saying that? It's because he is guilty.
This is similarly shifting the burden. This is saying that he didn't testify. Give us credit because our victim did. It's lessening what they have to establish by putting his right and his exercise of that right in juxtaposition with her willingness to testify, her willingness to participate.
This is what an appeal looks like.
And defense counsel opened the door to a comment on silence?
Yes.
And I guess kind of three-part question, sorry.
No worries.
What is the test for when that happens and when it doesn't? And did it happen here?
So the court or defense, to your first question, yes, defense can open the door. And the cases that have been briefed on this, Acuna Valenzuela talks about fair rebuttal to defense argument. And then that cites to State v. Gillies, which talks about defense opening the door to a comment about testimony. So yes, these cases exist. And I think the fair rebuttal test that we've been looking at is when defense brings up information related to testimony that either did or didn't happen. The question is the prosecutor's argument fair in response to what was brought up by defense? And in this instance,
this is a fundamental.
We're going to go back to Judge Simpson, though.
Seems to me that the fair rebuttal is, I guess, an exception. It's kind of a waiver.
This is how I watch court every day.
Counsel waives his client's fundamental constitutional right by making comments during closing argument, but I guess the Supreme Court says they can. But we need to be pretty careful with that. I mean, I suppose if defense counsel gets up and says my client testified as to X, then defense counsel or the prosecution can get up and say he didn't testify. But it's hard for me to imagine other scenarios where it's okay, given the nature of this right.
Okay.
And I would
1720. At this point in time, Your Honor, based on my discussion with Mr. Williamson, I would ask the court to consider amending those to personal bonds. He is 28 years old. He is gainfully employed working at a place called Little Diablo, which is a salsa factory.
Little Devil Salsa Factory.
He also cares for his father, who is suffering from cancer. He indicated to me that if this court was likely to continue any no contact orders, he does have a location where he could live with his grandmother in Romulus, or alternatively with his cousin in the city of Detroit. It's also my understanding that there was another matter that was pending before this court, and that Mr. Williamson has made all court appearances in that case. There's never been a failure to appear, was compliant with bond in that matter. From what I could tell, he has no assault of criminal history of any sort. I only saw traffic matters on his records. The complaining witness is here today. It's my understanding that she was asking for the no contact order to be lifted, but it is my understanding that the court intends to continue that pending the preliminary examination. But with that being done, I would ask the court to consider releasing him on personal bonds with a GPS tether if the court felt that was appropriate, or any other conditions, so that he can be out to resolve these cases. Thank you.
Your Honor, I would object at this point. I did see a previous conviction for an attempt RNODP that were resolved under HIDA. I did also see the out of Northville for disorderly, Westland for loitering, and Novi for driving with license suspended. I have concerns given these two cases, the first being the GBH. I had concerns given the facts of the case and the injury clothes that I saw that had redness and bruising on the victim's throat, the laceration on her finger, bruising to her shoulder. From that event that occurred while she was pregnant at the time, where the defendant strangled her. I also concerned with the new case, given that it was reported he was driving erratically from Detroit to Ann Arbor with speeds of reported over 110 miles an hour by the victim. And when they returned home, he took her car without her permission, and that led to the unlawful driving charge. So I have concerns, would ask that bond remain as set at this point.
May I add one thing?
Yes.
Just for the record, the complaint and the assault GBH, that incident happened on January 17th of 2025. So we're at about almost a year. It's my understanding that there was no contact order prior to him being arraigned on that matter recently. And that he and the complaining witness had been having contact throughout that time, Judge.
Throughout that period.
Correct.
All right. What I'm going to do with this, since we're actually very close to the exam, I'm not going to change it of the bond. I'm going to deny your request. Let Judge Washington hear the exam and let her proceed also. And I realize the alleged victim is here, wishes the court to change the contact provisions as I had indicated to council, I am not going to change the contact conditions at this point either. All right.
Thank you, Judge.
Thank you. Court does call the case of the People versus Robert Harris.
Robert Harris sounds familiar. Who's Robert Harris? Why the luck?
Jennifer Water, Assistant Prosecuting Attorney for the People.
But nothing was ever sent.
What's your name, sir? Robert Harris. This is still a PD case, but somebody had indicated there might be a conflict, but I don't have anything, so I don't know.
I wasn't contacted about this either.
Pardon?
I wasn't notified either.
Your Honor, Assistant Public Defender Jay Bellinger, on behalf of Mr. Harris, I would ask for a brief adjournment so that I can handle it and I can make sure it's handled properly. If you just give us a couple weeks so we can get that done.
I wasn't notified about this court hearing.
Will be adjourned December 30th,
but I'm here.
2025, 9 a.m. Where's your invite indicates?
That's Arizona Court of Appeal.
Okay.
Bond continued. Thank you.
We'll have an attorney be in touch with you as soon as possible.
They're only live during the hearing, then the
Court
video's
does call
gone
the case
afterwards.
People versus Jade Wimberly.
I'm down, Assistant Prosecuting Attorney on behalf of the People.
Assistant Public Defender Davey Liebe on behalf of Ms. Wimberly. Ms. Wimberly, can you please tell the court your name?
Hi, I'm Jade Wimberly.
Thank you.
And during requesting adjournment, I did email Mr. Dowd regarding a plea offer in this matter. I believe we're still discussing that, and I would like to address bond.
Probable cause conference will be adjourned December 30th, 2025, 9 a.m. Yes, that's the bond.
Thank you. And with regard to bond, Ms. Wimberly indicates to me that she was previously hospitalized at her prior failure to appear. I've not been able to receive any verification of that. However, Ms. Wimberly does tell me that if she were released, she could stay with her mother in Detroit, and we would have no objection to attracting her home confinement tether to ensure her appearance.
I don't need a response. Motion to bond reduction. Section E is denied. Bond will continue.
Thank you.
Court does call the case of People versus Dustin Hufford.
Assistant Public Defender Alexis Zerps with on behalf of Mr. Hufford. Can you please state your full name for the record?
Dustin Hufford.
Your Honor, we'd be requesting an adjournment so we can begin some plea negotiations.
Probable cause conference will be adjourned January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you, sir. Court calls case People versus Jason Campbell.
Jennifer Water, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Davey Liebe on behalf of Mr. Campbell, who stands to my right. Mr. Campbell, can you tell the court your name, please?
Jason Brett Campbell.
Thank you. Thank you, Your Honor. I do believe that we're going to have a resolution of this at our next probable cause conference. Would be requesting an adjournment for that, and I would like to address bond on this.
It's the only thing holding him, or?
Your Honor, he does have an out-of-county hold. It's unclear if they're going to pick him up, but that hold has prevented him from being released to treatment.
That what?
The hold has prevented him from being released to treatment, but it's unclear if they're going to pick him up.
Okay, because anybody say anything to you about Sacred Heart? I don't.
No, I called Sacred Heart, sir, and we set everything up, and my hold's preventing me from going to Sacred Heart.
The hold from the other court.
From the other court in Detroit, yes.
Because I've released him. I approved release to Sacred Heart.
Yeah.
This case.
Yes.
So what do you? Go ahead. What are you asking regarding bond?
Thank you. I would ask if he could be released on a tether so that he can either be picked up on the hold and then go to treatment if he's released there, or if he could then.
You got to get the other court. I mean, I've done what I could on this one so that he can go. you got to get the other court to do something, Mr. Lee. Well, I mean, that's why I asked the question, because I remember signing the paperwork.
Yeah, he did file a writ, Your Honor. Unfortunately, my understanding that there hasn't been a response.
Yeah, there hasn't been a response. I filed it 5 weeks ago.
5 weeks, no response. 5.
A probable cause conference, I'll put him on the 30th, 2025 at 9 a.m. And I'm going to deny your request at this point and see where we are on.
Your Honor, can I say something?
Oh, you sure can.
Your Honor, I mean, I've been in here close to 90 days. My mother just got denied. She just got denied a heart transplant through her insurance company. I just want to be able to see my mom. Please, Your Honor, please. Please.
Send me information that the other court is not responding, and I'll consider something else. But at this point, you know, I did what I could to try to get you out, sir. It's not me. It's this other.
No, if I get let out on a personal bond, they come and get me. They want the same thing for me in Detroit is to go to treatment. That's all they want.
Well, then you guys need to get to, what court is it in Detroit?
36th District.
Somebody needs to just get through to that.
I'll reach out to them, Your Honor.
And just keep banging on the door, because there isn't a reason he should be able to get out. Certainly on my case, he can. But he's got to be able to get out on their case. I don't know what, they have not issued a warrant because he hasn't done anything. Right?
The warrant
was
issued.
Have a hold.
Yeah, it's a hold.
And what my notes indicate, Your Honor, is that the call was made to the court. They indicated they would not be picking him up, but a lien message was received by the jail indicating they would be picking him up.
Well, see, again, that's not me. Somebody's going to need to make a determination. If they're not going to pick him up, then we'll do what we got to do. I mean, it won't be an issue. If they're going to pick him up, then we can figure out something here. They can come get him and then deal with him there. But they got to make their call.
Yes, Your Honor. I'll reach out to the 36th District Court.
Thank you. Court does call the case People versus Demarion White.
Please, Honorable Court, David Burgess on behalf of Demarion White, is appearing via Zoom from the Juvenile Detention Center.
Yes.
Mr. White, place your name on the record, please.
Demarion White.
Your Honor, I was literally just appointed on this case. I have yet to meet with Mr. White. I'm requesting an adjournment of the probable cause conference for that as well as discovery. And I think there's a green sheet.
Yes, I do have a green sheet. Does he have co-defendants and we set those other places or not?
Andrew?
There are no co-defendants.
Not on this one. All right. So how much time did you need, sir? You did the 30th or the 8th?
The 8th. I'm back in front of you on the 8th.
That's good. Probable cause conference, January 8th, 2026, 9 a.m. or as your invite indicates, bond will continue as denied. Thank you.
Thank you.
This is Ms. Burgess.
It's 12
Court calls
straight
case
up.
People versus Caitlin Davidson.
You guys want lunch right now? I want to see what Motorola Razor is making for lunch. Who's this?
I'm here.
Morning.
Okay.
Good morning, Your Honor. May it please this Honorable Court, David Burgess on behalf of Caitlin Davidson, who's appearing via Zoom. Your Honor, it's my understanding she was here earlier. I arrived late, so she was present.
Yes, you were late.
I called. I emailed her.
She told me you were late.
I know.
She was screaming into the Zoom.
That's fair. That's fair.
She was really mad.
Yeah.
All right. Ms. Davidson, can you state your name, please?
Caitlin Davidson.
Thank you. All right.
Your Honor, again, I was just appointed on this case. I'm requesting an adjournment for discovery purposes. And the 8th is fine.
She didn't say all of that.
No, I'm just fine, Judge.
You know that was me.
I could see her smiling, Your Honor, so it's a dead giveaway, Judge.
All right. Ma'am, I'm going to adjourn your case out to January 8th, 2026. 9 a.m. Yes, ma'am.
I have a court in Wayne County on January 8th at 10 a.m.
So you'd rather go there than to come see me?
It's cooking with
You're like
Motorola
Mr.
Razor.
Burgess. You guys ought to get along real well.
I know, I just don't know how like I'm gonna go about that.
Could she
Like, I
appear
don't know
on
what
Zoom
I'm.
on the 8th?
She can appear on Zoom, but I'll give her, I'll set it for the 15th.
That's fine, Judge.
All right.
Okay, thank you so much.
So that way everybody's not stressing. Nobody wants to come see me again.
I'll come see you.
Thank you. January 15th,
Okay, thank you.
2026, 9 a.m. Bond
I'm
continued.
almost positive I see you every week, Judge.
Yes, I know. Sense.
I think we're peeling some
Court
potatoes,
calls
getting
case
dinner
People
ready.
versus Ronald Fleming.
For the people.
Defender Jake Bellinger on behalf of, but not with Mr. Fleming, Your Honor. He has been for the last several months as we tried to visit him. And obviously, we need to eventually process this case. However, I just don't know how we're going to be set to do that. I understand that he'll want us set for preliminary examination, but
He wants to?
that's my understanding. The last time we talked to him, he did. I know he's been going through the competency. I know he recently came back as competent. I will be following up with the CFP just so that the court knows with the criminal responsibility. So that's my next step. And I understand that if he comes back and they give him a determination for NGRI, I imagine I could waive him up at that point too for purposes of petition, et cetera.
And I'm not sure if they'll do that before bind over. Sometimes they do, but it's not a given. So at this point, Your Honor, I do think people are going to be filing a motion to proceed without him. We do need to get the case moving. It is a homicide. It's been about a year and a half now, so it's time. We can just get a short date, and I'll have that motion filed. Get time for defense to respond. I don't know what there is to respond to really, but I'm happy to give that time so that way they can make any record they need to make as well.
So if I set it for the 8th, is that going to give everybody enough time?
I can have it filed by sometime next week, and I should give defense hopefully enough time with the holidays.
Probably
Certainly.
January 8th, 2026, 9 a.m. I'll also, there's going to be a motion.
I will tell the court it'll be that same sort of iPad in the cell motion, for lack of a better term, to sort of give him his advice. So that way, if he does continue to refuse, we can proceed to the preliminary examination.
I'll set it on that. Then I'll set it on that date at 3 p.m. for the motion part of it.
Okay, thank you, Your Honor.
And also for a, right.
1:08, 3 p.m. Thank you, Your Honor.
Yeah.
Thank you.
We'll mute this for just a second. I am aware of the plane crash that just happened in North Carolina. I'm very aware of it because my son is flying to North Carolina right now. He's on Delta, though. It was a private small plane. Apparently a former NASCAR driver owns that plane. Don't know many details beyond that. But
he's in custody.
Oh, that one.
Yeah. If you're going to read them, I'll call for it.
Oh, yeah. Well, yeah.
Motorola Razor needs to share the recipe with us, or at least show us the before and after pictures if he's cooking. I think he's cutting up potatoes. Gigi, there was a plane crash in North Carolina. I'm aware of that because my son is flying to North Carolina right now, but he's on Delta, and it was a private plane that crashed. So did not involve my son, which I'm feel good about, but it's always heartbreaking when we see a plane crash and there's loss of life, which I think there was in this one. The plane that crashed was in, I believe, Statesville, North Carolina. My son's flying into Raleigh-Durham. I might have to go pick him up in a couple hours. He's in the air right now, I believe.
Oh, court recalls the cases of the People versus Stone.
Trustee Phelps for the people.
Stephanie Kim on behalf of Mr. Stone. Stone, could you please restate your name?
Michael Stone.
All right. I think we were at the point, and I have now been handed and reviewed Ypsilanti Police Department reports for their case number 259672 and 259663. There is no objection to the court having reviewed those.
No, Your Honor, thank you for doing that.
No objection at all, Your Honor.
All right. Based upon the court's review of those reports, the court does find established a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Mr. Stone, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your pleas and would not be entitled, the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, completely.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am aware of none, Your Honor.
And has the court complied with the court rule? Would it be proper to accept the defendant's no contest plea?
You have, Your Honor.
Court will accept the defendant no contest pleas to counts 2 and 4. Count 1 is dismissed. There is actually technically no count 3 because it was not authorized. So count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
January 7th at 10 a.m.
January 7th, 2026, 10 a.m. for Judge Barr.
Your Honor, may I address bond?
You may.
We simply are asking for the court to allow him to be released from treatment. It's my understanding he was in treatment, a warrant was issued, and he was picked up from treatment. He wants to go back to the facility.
So he was in treatment, warrant gets issued, they come to treatment, they get in.
From treatment?
Yes.
Why?
I think there was a failure here connected to the warrant that got issued.
Because, yes.
Oh, yeah.
Yeah, so.
Yes.
He was in
absolutely,
treatment.
1000%. He was in a long-term treatment facility, so.
He was in treatment.
Yes.
Failed to appear because he was in treatment.
I would allow
Warrant
him
was
to go
issued.
back to treatment.
They took him out of treatment. Now he gets to go back.
What are you trying to hand now?
Just,
You actually had the order?
always. What? Yes.
Got the green
I'm
sheet
a
right there.
professional.
No, you haven't. No, you haven't done.
Yes, I'm a
Thank you.
professional.
Like, some things just happen. This is like a blind squirrel finding the nut.
Merry Christmas. It's a
It's
Christmas
the second
miracle,
judge
Your
who's
Honor.
made that.
All right. Bond will continue, but I've signed the order. Allowing
fries
you
in
to
the
go
grease, I
back. Good luck to you, Mr. Stone.
Thank you so much.
Cooking
Court
some
does
fries right
recall
now.
the case. People versus Ariana Fenn.
Wonders, prosecuting attorney for the people.
J. Grant Miller, P58658 on behalf of Miss Fenn.
She is no longer here.
Your Honor, at this point, could the court adjourn it to the other date for the other Fenn? I believe we have the forms in. I don't know where she disappeared to. She has been
What
on.
date did we put the other Fenn on?
Yeah, we'll have to look, Your Honor, I don't know.
Is it the 30th or the 8th?
The 30th,
The
Your Honor.
30th.
Probable cause conference, I'll adjourn to December 30th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
And he's done, just like that. All right. Let's go to Stephanie Boyd.
End up delivering the child in the middle of the night or water break, something like that. And
Do you have an objection to tracking?
I do object to the check, and I thought we had an agreement last time real quick that his current conditions can be amended so that he can attend any doctor's appointments that may still be remaining for his wife's pregnancy, as well as obviously go to the hospital with her on the day that he is to deliver.
The problem with that becomes GPS does their job well, and they can't know when something is maybe going to happen. Childbirth cannot be planned, unfortunately.
Oh, no, if there's a violation of a bond condition for GPS, it comes to me, they send me an email.
No, I understand, Judge, but you're normally not going to be checking that at 12 o'clock at night or on the weekend.
No, it comes to me and then I make a decision on whether or not to sign it. They don't like send it to somebody else because I'm not there.
Yeah.
And what I can tell you, Mr. Vaccaro, with regards to GPS, what ends up happening is when they file a GPS and they say there's a violation, the first thing that they do is they call you and they let you know, hey, where are you? We have a alert that you're not where you're supposed to be.
Is that a tuxedo
So,
jacket?
If, for example, and I'm not saying I'm going to deny council's motion, but if you were at the hospital and GPS doesn't show that you're supposed to be at the hospital, the GPS tracking is going to show that you're at the hospital. And then if you're at the hospital, normally they won't call because they'll see you're at the hospital. But if for some reason they feel like you should not be there, they will call you and you can say, my wife is giving birth. This is where I am. All right. But you can continue. Do you have witnesses?
I do have one witness, and I think the concern, Judge, becomes if the monitor starts to go off in the hospital. I don't know if the staff, such as the nurse and doctor, are going to feel comfortable with him having a GPS monitor ringing while they're trying to deliver the child, and will they let him stay in the room or not? And I can just see that becoming a traumatic event for his wife and him. And I don't think that's really necessary at this particular juncture of the case, considering he hasn't had any violations in well over a year. But I will call her to come stand. America Willis. So it doesn't have to be support system. Take a step back. Thank you.
We have a witness.
All right. Can you raise your hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. State your name for the record.
America Willis.
All right. And how old are you, Miss Willis?
23.
All right. You may proceed.
Ms. Willis, are you currently expecting a child?
Yes.
Who's the father of that child?
Pickles for Kara.
Okay. And are y'all married?
Yes.
Okay. And when did you, well, we don't need to get into that. Currently, where do you reside?
Is my mother.
Okay. And do you live with Mr. Becerra?
I can tell you all right now, nobody can hear anything that's being said.
Sorry.
I can't hear. The court reporter is struggling to hear. I don't know. Today, everybody seems to be whispering.
Yeah. So if you can please speak up so everybody can hear you, and we'll add the microphone, that might help. Where do you currently live?
I live with my mother.
Okay. And does Mr. Becerra live at that residence?
No.
Okay. Is that because there's not enough space at that residence for both of you?
Yes.
Okay. And also he has a bond condition of where he can and can't stay and when he can come and go. Are you aware that Mr. Becerra has a GPS bond condition?
Yes.
And you understand he has a monitor on?
Yes.
And it limits his movement? Okay. Right now, how many months pregnant are you?
9.
Do you have any other support system that can take you to the hospital?
Currently, no.
Do you have anybody else that can help you pick up formula?
No.
If you need help taking care of the child after the child is born, will you have anybody else that can be there to help you with that?
No.
And so Nick is really your sole provider for any sort of aftercare that you need after having the birth of the child.
Yes.
As hard as to say, you do understand that some people do have traumatic births and that sometimes it has recovery time.
Yes.
And it is possible that could happen here.
Mm-hmm.
Okay. So are you asking the court that he either have tracking only or have this device removed so that he can help you during this time?
Yes.
Okay.
Judge isn't buying this.
Have you experienced him coming to a doctor appointment or trying to come to something and his monitor go off and start beeping or having issues with it?
Mm-hmm.
Okay. And does he normally get his appointments approved by the GPS officer usually? Or is that sometimes hit or miss?
It depends.
Okay.
We've had one appointment.
Okay. One doctor's appointment that he's been able to go to because he has to get it approved in advance. Okay. But if he doesn't get it approved or they don't respond to him, can he just go?
No.
So everything has to be approved in advance?
Yes.
And in your experience, are these GPS officers overworked?
Yes.
Objection, relevance.
All right, that'll be overruled. You can answer.
Okay. Does it seem that they sometimes have a hard time responding?
Yes.
And they sometimes say, only email me, do not call me, or things of that nature. They have certain preferences.
From what I've heard, yes.
Okay. And so are you asking the court that you be able to have father of your child, my client, Mr. Becerra, at the birth and able to help you afterwards by getting tracking only or having the GPS device removed?
Yes.
And you understand, and I'm sure he understands as well, that if there is a violation, they can put him back on full house arrest if they want.
Yes.
Or remand him without bond if he violates in any way.
Yes.
Okay. And knowing that you're still asking that the court would put him on tracking only or remove the GPS device. Okay. Is there anything else that you would like to add that the court can use in making this decision? Thank you so much for your time. You can give me that back. And you can please go sit down.
No.
I have questions.
Oh, I'm sorry. Yeah, of course. Yeah, go ahead.
The judge is like,
Yes.
You said your name was Miss Willis?
Yes.
When did you first meet Mr. Vaquero?
2 years ago.
2 years ago. So that would be when you said you're 23, correct?
Yes.
So when you were 21, you met? And how soon after you met did you guys get married?
We got married December of last year's and probably over a year.
December. Okay, so December 2024. Okay, and when did you first realize you were pregnant? April of this year. Okay. As of right now, do you have any remaining, I believe they're called prenatal appointments?
I don't think you know. But we're doing Sunday.
I'm sorry?
I'm due on Sunday.
You're due on Sunday. Okay. Sunday's your due date. So with that being said, do you have a hospital in mind that you plan to go to that day should baby come? What hospital is that? Methodist and Methodist. Okay. Are all those arrangements already made with that hospital for that day? Okay. And you said, or you testified earlier that Mr. Vaquero doesn't live with you, correct? But who lives with you? I'm sorry?
My mother.
Okay. So in theory, your mother could help you out with the things Mr. Hagee was asking about as far as formula, diapers, etc., things for the baby.
He's pretty sick.
How is she sick?
She has cancer.
Oh, I'm sorry to hear that. I hope that your mother gets better. So I guess other than your mother, then it's just Mr. Vaquero?
Yes.
Okay. In your life, no other family support system, no cousins, aunts, uncles, fathers? Okay. I'll pass the witness, Your Honor.
Any further questions?
Judge, have any?
So you're a caregiver for your mother?
Yes.
Okay, so she doesn't have the ability to help you.
Mhm.
And Mr. Vaquero doesn't have parents in his life that could help either.
We're doing it on the 29th.
Grandparents that could come and be a caregiver for you or anything like that. They don't have the availability to do that. That's it, Your Honor. I have no further
All right,
questions.
I just have a few questions.
Sure.
A week from Monday, right?
Before you started dating him, were you aware of these pending charges?
Yes, yes.
All right, thank you.
Ivan, you are an OG, 32 months. Thank you, my friend. Festivus, I believe, is on the 29th. The mods are all going to be sick that day. Just kidding.
All right, this is what the court is going to do. The defendant is allowed to attend all medical appointments involving his wife and his future child, and there's to be no unsupervised contact with minors. All right, thank you.
So does that mean, you can ask me a question?
Don't ask me the question, says the lawyer. Shut up, who won? Shut up. Don't ruin it. Don't ruin it. You won. Just walk away, walk away, walk away.
Okay, thank you.
Oh, man. Yes, if you've got grievances to air, make sure you get the form in. That will help a ton. And Amber, we need to talk about the form once, we need to spend some time going over the form and helping me get everything ready so that we're on the same page as to how the actual show will roll.
Amanda Farias. And which page is she on?
He is
I don't know what its charges were.
Section 1 down.
We missed that one. Might be family violence. I've been doing a lot of family violence stuff.
All right, just have a.
She just walked out. She goes, turned around. She walked right back out. I like all the festive, the reds and I like the solid colors in court. Can you tell me what a grievance is? It's basically a complaint.
I have page 5, third one down. Rafael Rodriguez.
Something you've been harboring in your soul. That
Rafael
you just need to
Rodriguez.
President, Honor, lost track of the prosecutor.
Oh, that's okay. Where's your Mr. Rodriguez?
By the way, good morning, Your Honor.
Good morning. How's it going?
Good, good.
All right. Did the state tender an offer?
He's very blue.
Yes, Your Honor. We're in the process of attempting to negotiate a pretrial diversion protocol.
All right. State. On Rafael Rodriguez, is this going to be a PTD?
There'll be some of that.
He's on page 5, number 3.
Yes, you can file multiple ones.
Rafael Rodriguez.
Yes.
Do you confirm anybody was first?
Yes, the gentleman in charge of elderly crime.
Oh, Hunter.
He was here a while ago now.
This is Hunter's case, Your Honor. Let me text him.
Okay.
You want us to back up?
Yeah, just have a seat and I'll call you back up. And Melissa, if you can just text him to see if they have come to an agreement on a PTD. All right, who's next? And just so everyone knows, 11:40, the court is taking its recess and you all will have to be back at 1:30. There's no need to rush the court because you're gonna have to be back at 1:30. Anyone else ready?
I have Kevin Williams. I'm just trying to find him.
What's the name?
Williams, Kevin.
Kevin Williams. Who's the attorney?
I am, Your Honor. Good morning.
Good morning.
Somebody's excited.
Let me find what page you're on.
Oh, page 13, Judge, third one down.
Good morning.
Good morning, Ron.
All right. Have you received an offer?
We received an offer today, Your Honor.
All right.
Waiting on a little bit of additional discovery.
All right, Ms. Ferguson, set this for a plea deadline date.
Ms. Ferguson is doing.
All right, this is going to be set for a plea deadline date in January. And I will set you for January 22nd. All right, once you received the reset form, you sign it, you'll be excused.
Yes, sir.
And that will be your plea deadline date.
Yes, sir.
All right, thank you. Yes.
Hunter said that he is going to consult the complainant and then he will let him know if he's going to give him a PTD.
All right. And what is your client's name?
Rodriguez, Your Honor, Rafael Rodriguez.
Let me just find him again on the docket sheet. Thank you. Mr. Rodriguez, if you'll come forward. All right, Mr. Rodriguez. I'm going to recall your case in January, and it's for the state to make the decision on whether or not they're going to proceed with a PTD for you. All right, so I'm going to recall this for January 15th. All right, once you sign the reset form, you'll be excused. So just have a seat, be patient.
Thank you, Your Honor.
Thank you.
Sorry, Judge, which one's over?
It's Rodriguez.
Sorry, I'm talking to Mrs. R.A. It looks like I'm going to have to go pick up my son. I'm going to get to go, excuse me. I have the opportunity to go pick up my son from the airport as he flies in this afternoon, which will involve me leaving here by 3 p.m.
All right, who's next?
So we can work through lunch if you want.
All right, are the parties here on Amanda Farias?
Alma Benavides Zoom
That sounds
music.
like that may end up being in the afternoon.
I like her globe.
Anyone else ready?
Her globe has its own closet.
Okay.
Alma's like, I'm ready. Raise my hand. I'm here, Judge. I am excited. Adding pre-grievance qualifiers gets you double grievance.
What did she say as well?
Determine whether we're going to qualify for.
And Miss Benavides, we're just waiting for you. I'm just waiting for them to give me your paperwork.
You can't have a grievance about the court hopping confusing and going too fast, because I warned you. We said court hopping, and there must be hops if we're court hopping. Hey, Mrs. Ari, how are you doing? Do you want to talk? No?
I was hiding.
Oh. Do you want headphones so you can hear what's happening?
There was a motion.
What's happening? Just
We're listening to Judge Boyd. She's calling cases. She's in a grumpy mood. Like someone peed in her Cheerios this morning or something.
Oh my goodness.
Yeah, it's not good. She barely let a husband show up to his wife's birth.
Judge, I just turned him in
wife's
for custody.
birth?
I have to be in Medina County at 1:30, so I was hoping, I've got an agreement.
He needs to be present for me to do a motion to set bond.
He's here.
Happy Thursday, Simply Nikki. Thank you very much. 10
And I've got an
months.
agreement with the state judge of court.
I don't know if I'm gonna follow that, but we shall see.
Mrs. R.A. did have some pecans.
Those were good. Is that Josh?
It is Josh.
Josh, those were good. Those were like cookie level good. Those were good.
Their pecans are sweeter, especially than sidewalk pecans.
Renee's
Sidewalk
here.
pecans are junk.
If I need co-counsel.
Oh, yes.
What makes
Renee,
pecans
I told him he
anything,
should have given
but some of them
you,
make me
you know,
itchy in my
payback.
mouth.
Oh, no, it's okay. Maybe lunch or something someday.
Yes.
You good said.
All right, let's make this happen. So when are you gonna take Renee to lunch?
I need to, Judge, for sure.
Part of the mentorship program. There you go. I'm checking in the locker room.
Renee, see, you see how I make people commit?
Yeah.
He's like, yeah, it's something I need to do. Yeah, but when?
Well, you know, as soon as Renee has an opening.
Yeah, there you go. Into the new year, presumably.
You're right. So let me pull out the calendar.
Can we have a Christmas cookie baking live with R.A.? Hey, I will tell you this.
So Renee, are you available for lunch with Mr. Hancock on January 15th?
Sure, Judge, sure.
All right, so he's available January 15th?
It is.
Did you just set up a date?
Be in contact.
Yes, sir.
Thanks, Thank you, Judge. You can have it.
All right,
She
the
did.
court is calling 2024 CR 2214 State versus Shepherd, Eric Avila Jepson. Can I have parties announced?
Melissa Albin for the state.
Pat Hancock and Mr. Gibson.
And are you Mr. Jepson?
Yes, Your Honor.
Amber, plural?
All right. Defense has filed a motion asking that bond be set in your case. Was there not a bond previously set?
There was, Your Honor. He has an MTR filed, so his bond, he was remanded.
All right, does anyone have a copy of the MTR?
Mr. Hancock had one, Your Honor.
There it is. Judge will review.
This kid looks terrified.
Yeah, he wants to get his bond changed. He's not in custody, though, so he had no bond, but now he's asking for a bond change? What? Lowering bond?
All right, there's a request for bond to be set. And it's the court's understanding that you all have reached an agreement?
It is, Judge. I've conferred. We've reached an agreement to set the bond at $30,000 if that's okay with the court.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jeffrey Gibson.
All right, since you've been placed on probation,
MTR is
have
a motion
you
to revoke, by the
suffered
way.
any type of mental health issues?
Motion to revoke.
No, I have a they waived medical marijuana for me for my I got a gunshot in my leg.
All right, so have you ever seen a psychiatrist in the past?
No, but I got the gunshot regarding PTSD.
All right,
Who diagnosed you?
and have you ever used any type of drugs in the past?
No.
All right. The court will follow your agreement. The court will set your bond at $30,000.
That's
There's to be GPS, waive fees, and it will be full GPS. Is there anything else with regards to this hearing? All right, we can go off the record.
Here comes some
We
advice.
need to have this
Life
motion
advice.
set. Ms. Ferguson? She's not here, Judge. Yeah, she's not.
Mrs. R.A. made snickerdoodles. And they're
Alrighty.
so delicious. Everyone's asking for the
Ms.
recipe.
Abrams?
Oh, two people have.
When would you like this set for a contested MTR? And if it's not contested, it's not contested. And
Judge, the first, January is blank.
all right, this is going to be set for contested January 7th. All right. Once you sign the reset form, they will transport you and they'll place this in the system.
Thank you, Judge.
Thank
see
you.
That, see that lady on Zoom? See how she has like a closet for her globe? Like a little nook? What else would that be for? That's like a custom globe.
Books.
It's a globe
It's
nook.
for books.
No, it's a globe nook.
What did he do for a $30,000 bail?
I don't know, but he got shot at one point, and now he
All right,
smokes
thank
weed
you.
to help deal with it.
Sign-up sheet.
Oh.
Josh is sending a super chat that just says cookie recipe.
Oh, it's not mine. It's Snickerdoodles from the Pioneer Woman, or the Pioneer something.
Who's here on Ruben Villarreal?
We'll get it for you. But they're the best cookies. Everyone's like,
They are good. Like I
I
ate
told
them.
her. I
was
told
like,
her. I'm like, quit the pumpkin
right.
chocolate
Thank
chip,
you.
just Snickerdoodles. That's all we need.
Paper copy of the judgments. I didn't want to scan them as to not break the seal of them being certified. So I
All right.
totally
Is there going to be any objection to that, defense?
Judge about to break the seal.
You're on mute.
You're on mute.
This is on page 7 of your document. Thank you.
Alma Benavides, you're on mute.
No objections, Your Honor.
All right, the court is calling 2025 CR 009602, State versus Ruben Villarreal. Can I have parties announced for the record for the state?
Lauren Espinoza.
Defense.
Alma Benavides for Mr. Villarreal.
And are you Mr. Villarreal?
Yes, Your Honor.
All right. Did you review the document entitled Defendant's Consent to Appear by Video with your attorney? Did you understand it and electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Did you review the discovery? I'm sorry, defense, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Villarreal, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. State moves to waive the enhancement allegation and
Maybe
proceed
Spain.
solely on count 1.
Oh, yeah.
Spain. It's Spain.
Could be.
No objections, Your Honor.
Her name is Benavides. It's got to be Spain.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with theft of property, $2,500 or more as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Benton,
Yes, Your Honor.
County
You have
Jail.
a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
This is Bexar County.
No, Your Honor.
No. The answer was yes.
Yes. I don't want to.
You have a right to jury trial. Do you understand?
We'll break that down.
Yeah, I don't want to do
bite-sized
jury
chunks.
trial.
All right. So you understand that by entering into this plea, you're giving up all of the rights that I've explained to you, the right to jury trial, the right for you or your attorney to confront any witnesses against you, and the right to remain silent. Did you
Yes,
understand?
Your Honor. Yes, Your Honor.
Who told
Counsel,
him
has
this
your
was a good
client
idea?
been able to provide you with any defenses?
Yes, he has, Your Honor.
He's in Denton or
He has a
Benton.
rational as well as a
County.
factual understanding of the charges against him?
This court
I believe
is
he
Bexar
does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Villarreal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone
No.
promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargaining agreement with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, there's an $800 fine. Punishments to be assessed at 51 days in the Bexar County Jail under 1244. The state will take in consideration 2025 CR 010849.
And review
Did
the
you
same.
understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right. You're waiving
Bless
your
you.
right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then and outside the agreement, the state is requesting that you have no contact with HEB at
Heb.
10660
Oh.
Calabria Road, 78251. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
But she will, because that's
Yes,
her
Your
favorite
Honor.
store.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
We've reviewed them, Your Honor. No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments.
And review
and the
the
court
same.
will review the same.
All right. As she reviews the police record, like, yes.
Man, he
yes.
rolled the
Right,
dice
after
on her.
reviewing
I think
State's
he
Exhibits 1
lost.
and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we're asking the court to follow the plea bargain, and we wanted the court to take
Doesn't have to.
note that Mr. Villarreal was taken into custody on October 29th of this year, and he has been in continuous custody at the Denton County Jail.
Okay.
That would
All
explain
right, is
the
there
orange
anything
jumpsuit.
else?
Nothing further, Your Honor.
All right, the court will sentence you to 51 days in the Bear County Jail under 1244. Give you credit for any time served. There's an $800 fine. Take in consideration 2025 CR 010849, and there's to be no contact with HEB. Did you review the document
Don't go to HEB.
entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
And did you electronically sign it?
Cream of
Yes, Your
tartar.
Honor.
Essential. Instant.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Good luck
did
to
he
you,
do at
sir.
HEB?
Stop stealing. Otherwise, you're going to find yourself
he's
living
like-
in the
he's
jail or
acting
the
like
prison,
this is a good
okay?
thing, but it
Yes,
does
Your
not
Honor.
sound like a
Thank
good thing to
you.
me.
Stop
Christmas.
stealing.
Oh, Merry Christmas to you too.
Is that what she
Thank
said?
you, Attorney Benavides.
Thank you, Judge. May I be excused?
Yes.
You may go
Thank
back to
you.
spinning your globe now.
Is the person here on Amanda Farias? All right, Amanda Farias is,
Okay. Love you.
all right, that's going to be 1:30.
Okay, so
Anyone else ready?
we have to decide what we're doing today. Are we going to take a lunch and call it quits, or are we going to work a little bit later?
There's a contested MTR on the docket for Angel Cantu. I know we got an issue with bringing inmates over, and defense counsel really needs to confer with his client. Can his client clear via Zoom potentially? And I think that may resolve.
Well, the intention, Judge, is whether a hearing is necessary, and I know the state has witnesses, so I want to be able to, so that they can go about their business. If it is not necessary,
You'll have to talk to the deputies to see if that's possible.
okay, thank you.
Well, it's okay with Your Honor?
Sure.
Okay.
Just want to be efficient, Judge.
No, I appreciate it.
Just to reapproach on those by the end, it's on page 17, third one down.
Get back there until you get called.
On which one?
On Rose Padilla,
Yes.
page 17.
Yes.
Third one down.
Yes.
Okay.
It's on Mr. Rios. I put them, put my.
No, I'm sorry, Rose Padilla
Oh.
first. That's okay.
Yes.
Yes.
We have, I think we have reached an agreement we're gonna plead true to one of the,
All right. Are you all ready to come up then?
yes.
Rose Padilla.
All right, the court is calling 2015 CR 3473 State versus Rose Padilla. Can I have parties announced?
Ashley Jones for the state.
Robert Valdez for Rose Padilla, Your Honor.
And are you Rose Padilla? All right. My understanding is that you wish to change your plea to true on one of the allegations.
Look at this Christmas sweater.
You need to speak up. All right, state if you
It's a
read
nice
the
penguin
allegation.
sweater. I
Yes,
like
Your Honor,
it.
apologize for 1 moment.
How festive.
Violation of condition number 23 in Bexar County, Texas. The defendant, Rose Padilla, did then and there fail to make payments of $100 every 2 weeks in violation of condition number 23.
How do you plead to that, true or not true?
But she kept all the other 22.
All right, did you understand by pleading true to violation of condition number 23, the court could find it true, grant the motion, sentence you to 20 years in the prison and up to a $10,000 fine?
20
Knowing
years?
that, do you still wish to plead true to violation of condition number 23? Court will find violation of condition number 23 true. What is the state requesting?
She didn't pay
Your
her fine.
Honor, along with probation's recommendation, the state is requesting that the court grant the motion to enter adjudication of guilt, revoke the defendant, and place her on probation or community supervision for 10 years.
Well, no, is this an aggravated assault with a deadly weapon? Or is this, I think this is aggravated assault with a
Let
deadly
me
weapon.
check and see what
So,
led to. I apologize. Can we step back for a moment?
sure. So what yeah.
Yeah, let's back up a little bit. All right, we also have in 45 minutes we have the hearing with judge, the judge that was shot by the sheriff. I say was shot, not allegedly, because it happened on video and we watched it. Sean
right, anyone else ready?
Coming up. So we'll see if we can watch that, and then we'll probably call it a day.
Okay, just 1 second. No. What's the name? Did you say Alvarado?
Yeah, Francisco.
I mean,
I gravitate towards thumbprint cookies for the DNA aspects. Leaky red jam makes crimes and cookies.
Fifth one down, Edward Rios.
And two thumbprint cookies. That's cool.
Edward Rios.
Don't use a fork. Use your thumb. Just mash it with your thumb. The mods have been outnumbered. The mods can take a lunch. You're fine. You can go. I will. I'll handle it on my own. It's nice.
Were you able to
quiet.
tender an offer?
Yes, Your Honor.
All right, I need an acknowledgement of discovery done before you leave here today. And Ms. Ferguson, I need a plea deadline date.
You know, we what? Sometime in January.
Yes.
I can do January 13th.
All right, January 13th is your plea deadline date. You need to let the court whether you've reached an agreement after that. If you have not reached an agreement, your next setting will be jury trial, and the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, sir.
All right, thank you.
Thank you, ma'am.
Yes.
The sheriff Stein's case is wild.
Oh, no problem.
Yeah.
You've got this murder.
Wanted to introduce myself. My name's Brandon later. I'm going to be in the second chair for next year. So I thought I'd come see y'all.
Hey, welcome.
Oh, thank you, Judge.
Thank you.
It's in here, so
Okay, thank you.
How are we doing?
You too. All right, who's next?
I'm still working on these.
The murder is sensational. It happened on video because he was the sheriff and he shot the judge in the judge's office.
They're ready to approach on Caroline Panera, Judge. They say we're close to
But behind that story, it exposed a sex for favorable treatment
She's on page 14 of the file, Judge.
All right,
corruption
counsel.
scandal. In the
Your case is
courthouse.
coming back
It's
for
spicy.
Your Honor, yes, I've heard her
judge
husband
was
are charged
involved.
with the same offense, Judge. I believe the court's already set her husband for January 7th trial date. I have a sentencing hearing in Medina County that morning. And I've been talking about, we're not anticipating severing this. I've been talking with co-counsel, or her husband's counsel. She wants to approach on a motion for an investigator and get an investigator on this. I just want to tell you where she's coming from on this. I've spoken and conferred with the state. He's got to get with his chief in order to determine if what we've discussed is kosher and copacetic with the district attorney's office.
So y'all have to have that worked out by January 7th.
Yes, Your Honor. But what do I do with the conflict in Medina County? I'm already set on a felony sentencing.
I would suggest coming here.
All right. I'll see what the district court judge wants out there.
All right.
That setting, I just want to apprise the court.
No, I appreciate that.
That setting was made. We had an MTR, the sentencing hearing. That setting was already in October. So I don't know what Medina County is going to want to say.
We'll see what happens.
Yes, Judge.
All right. Thank you.
Thank you, Your Honor. Thank you for your time. I have one more case. I'll be back straight after.
All right. Thank you. All right. Who's next?
And we're bringing her back what date, Judge?
January 7th. And that's jury.
Jury trial.
Do the discovery acknowledgement, Judge, or do I?
Yes. Thank you. All right. Anyone else?
She's saying we need to work together.
Judge, I appreciate you. Thank you.
Oh, thank you. Have a good one.
You back, Judge. I'll see you in a little bit.
All right.
Trying to butter up the judge probably for the next case. Yeah, the Sheriff Steins thing is going to be wild. If it goes all the way through trial, they're going to expose all the corruption in that courthouse through testimony in a murder trial. You're going to hear about judges giving women favorable treatment in return for special visits in the judges' chambers, sheriff's deputies involved, basically everybody knowing about it, like the whole town knowing about it.
Yeah, okay.
It's on the docket, Your Honor.
Thank you. Norma, everybody's coughing. What's going on?
It's the pre-Christmas.
Are we patient zero and we don't know it?
That's almost soundbite worthy. Not quite, though.
Until we bring such 2 years, yeah.
I'm sorry.
Space.
Yeah. Thank you, Judge.
The apocalypse may be upon us.
Yeah, Coach Your Honor.
Yes.
I had stepped out. Unfortunately, I had to go to the 175th. And you called Amanda Frias. Paperwork's ready. Clients here. We're ready.
Amanda Frias.
Did you give that?
I'm sorry, Amanda Farias. Court is calling 2025 CR 006129. State versus Amanda Lynn Farias. Could I have parties announced?
Rick Pena for the state of Texas.
Joseph States in for Monica Godetto.
And are you Miss Farias? All right. Counsel, do you want to place on the record your representation of her?
It's a retained case. Monica is retained on this one. I work for Monica Godetto. Miss Farias, do I have permission to do this in front of Judge Boyd today?
Yes.
All right. Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Farias, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. State, will we proceeding on count 1, paragraph B? We will waive paragraph A.
The Steins hearing.
No objection.
Is update status
All
hearing.
right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with burglary of a habitation. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Oh, no contest.
You don't want to go to a jury trial.
No, no, no.
You worked a deal out with the state. You wanted the judge to follow the deal.
Correct.
All right, so I want you to hear what I'm saying and internalize what I'm saying. You have a right to a jury trial. Do you understand?
Yes.
Do you want a jury trial? You want to enter this plea?
And then plea.
All right, you have a right for your attorney to cross-examine witnesses that the state calls, or you can cross-examine them yourself. Do you want to do that, or you want to enter into a plea?
Enter into a plea.
You have a right to remain silent. Do you want to remain silent? Do you want to give up that right, or do you want to enter into this plea?
Enter into a plea.
All right. Court will find that, just 1 second. All right. Did you understand, if I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Farias, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's to be no contact with Oscar Castro, Yemi, Vanessa Bayo, Mandragon, Jesus Leyva, and the address of... Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 7 years. There'll be 200 hours of community service restitution, the BIP course, TAP evaluation, follow our recommendations, and MRT. Is there a affirmative finding that's being requested in this case?
Per the code, this charge doesn't come with an affirmative finding, Your Honor.
All right.
It's for Title V offenses only, and burglary of habitation does not.
All right. Well, I'll read the facts and we will see.
Yes, Your Honor.
All right. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in paragraph B, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. At this time, state offers into evidence its Exhibit 1 with all attachments.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's Exhibits 1 and attachments and review the same.
She's a very fast reviewer. Burglary of a residence. It's a pretty serious one.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Our client's remorseful that this had happened. What's not in your the stipulations, not to your knowledge, is that there was some abuse, possible molestation from the complainant against her child, and that led to this event.
Well, have there been charges filed for that allegation?
Not to my knowledge, Your Honor.
Any evidence presented to anybody for that?
This is the first time I'm hearing about it.
Okay, all right, you may proceed.
The client is
we may have to bail.
Employed, self-employed, does meal prep. There's a $1,500 fine. However, she may not have consistent income. I know this is for 7 years. I was hoping that the fine could be probated. She does do not professional home health care, like not a caregiver per se, but she does have to be around other people.
She does unprofessional home health care?
In the sense of making sure somebody doesn't fall over. If somebody needs something, she may help them. We're under the impression that this was not the affirmative finding of family violence. I had advised her that it likely would be imposed. And I would hope that you would follow the plea bargain agreement as written.
All right, so why were you over at that location? Because it appears from reading the stipulations that you were not invited.
Correct. Well, I was informed that he was there by him. This was ongoing abuse that I had been through with him. He would stalk me. He, would find where I was. And that night I was with my friends and he was telling me that he was going to come looking for me and that he was going to find me. Anyways, it led on to the next morning. He was still contacting me. He told me he was there. I was telling him to leave me alone. Long story short, we ended up getting into it, over the phone. So I went over there to where he was at.
Don't stalk me, I'll stalk
and that's
you.
how I ended up there.
I'm confused.
I don't understand that. I don't understand why you would go to a location. Your attorney is saying you're in fear of him, but you go to the location. And then did you see the photos?
Yes, ma'am. And he's currently out. He was guilty of putting his hands on my son and myself as well. He's out right now. I think deferred. I don't know. I couldn't tell you the legalities of that, but and that wasn't his only time. After I was arrested with this, he came to my house looking for me again with a gun and put it to my head. And because there was a restraining order, he had one on me. I ended up getting arrested. And so this is, even me on house arrest, he was still messing with me. So I understand that I wasn't supposed to be there or I went looking for it, but I think that just me being, provoked and going through what I was going through with him, I snapped, I guess.
Well, if he's on probation, shouldn't he have a no contact order as well?
Well, I believe that was all done prior to this taking place. His own separate case that he was placed on deferred was completed prior to this.
So he's completed probation.
He's not completed. He's on deferred at this time.
All right, so there should be a no contact order. Is that out of this court?
I don't believe so. No, it's in a different court.
Oh, okay. Well, I would have ordered a no contact. So maybe somebody should let probation know to reach out so there can be no contact.
Yes, ma'am.
Do you all have children together?
No, ma'am.
All right, so there's no reason to have any contact with him.
Yes, ma'am.
Court is going to sentence you to 7 years deferred adjudication. There's a $1,500 fine that will be probated. There's to be no contact with Oscar Castro, Yemi, Vanessa. And Ms. Abrams, that's Yemmi. Vanessa Bello Mondragon, Mondragon, Jesus Leva Levya, and the BIPP course, TAP evaluation out of custody, follow recommendations. 200 hours community service restitution. I'm going to order the BIPP course. Once that's completed, 100 hours be deemed satisfied. The MRT course, once that's completed, 100 hours we deemed satisfied. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue where he's bothering you, you need to let probation know. And maybe you can see if their probation officer can recommend that as a part of his conditions of probation, that he has no contact with you. And then if he were, that would be a violation of his probation. My understanding, his case is not out of this court. Otherwise, he would have had a no contact order. All right, good luck to you.
Judge, just one clarification. The meal prep that she does is not significant. She does the side thing of helping others, where it's not in a.
Maybe she's just doing meal prep and dropping it off.
She may assist somebody with in the house movements, not make sure they don't fall over. She is not a nurse. She's not licensed. She's not a home health care provider in her sense.
If she's doing that for people, I'm assuming she has regular people that she does that for. Am I correct?
Yes.
You will have to get a letter from that person or their family stating that they're aware that you're on probation for this and they have no concerns with your providing that service.
Okay.
All right. Thank you.
Thank you, Judge.
All right. We're on recess.
We're on recess. Sorry, I dropped my phone. And when the judge goes to recess, we go to lunch. Is that the deal? It is 1 o'clock. I think we might have to call it for the day. And sadly, well, no. We've got 1:30. Wait. Don't call it. Come back. I didn't start the music. We have half an hour until the Sheriff Mickey Stein's hearing. It's going to be a short one. Mickey Stein's is live? Not yet. I'm not seeing Mickey Stein's be live yet. See, Thurston is live. Scotchman, where are you looking? When you say live, that means that the court's beginning right now, right? Mickey Stein's hearing. I show it's a 1:30. Oh, people can be streaming and talking about. People can be streaming and talking about it, but the hearing hasn't started yet. So unless you're living in the future, it's not live. You're watching old video. So we'll wait. We'll stick around for a little bit. We do have a couple other courts we might be able to go to, including, I think, Thurston County. Let me check Thurston County really quickly. Thurston County should be up. Show me who we have. Judge Greenwalt What's on her daily docket? Oh, she's not live. Thurston County Court 2 is up. Let's go to that one.
Very hands off. So Brody and Peter have developed their own methodology that I don't think contradicts Rosemary's at all, but
We
just
doing
set up
movie
their different
reviews?
office vibes. I was always like over prep.
Well, and over prepping now because God forbid
I know. Because I'm just like standing there like, I don't know what
well,
to do.
and also because a lot of this is so new to me, even being like I understand like theoretically how this happens, like legally understand the law behind it. Being like, what do I ask for? What does this even? What does this code mean?
Yeah,
Sometimes I spent so long trying to figure out reading in like the jabs and what is even happening, just because I'm like trying to
so many
apprise myself what is even happening, or like I'm like, how much time did they?
Yeah, oh my God. This calendar, for like the first couple weeks, I was doing it by myself. Well, Brody was like a backup, so if I needed him, but I was like, I keep giving myself more and more time.
Like this calendar is probably the only one that I'm like not worried about, but like
I still
perchance worried, yeah.
And like,
oh, our mic is up.
It will depend a lot
on
the
presiding.
judge. It's just they have their own style of doing things on this calendar and other calendars, so you'll kind of get a feeling of like, oh, I'm sorry, we're just like freaking chatting it up. Maybe I'll break out with whoever from chat, Preston. Are you good to go?
I saw the one about boom, but I was like, this is not mine too.
Yes, you can always reply to them.
Right, but I don't know the posture of that one, so I didn't know if you'd already like what you're.
They were just told that that's live, and they're still talking. So this is the prosecutors talking amongst themselves.
Sounds good. When was the last time? 10/16.
Let's see, there may be some news on another case here. Now they're quiet.
Phelps. Run away. So I think it's one I prepped because I'm not closing the first one. Started prepping like a Word document for this because I like to use tables, but then I just ran out of time. Yeah, see, he's at the bottom.
Today there's supposed to be a Courtney Clenny hearing.
And that's like I always want to say just yes.
Not sure if this happened or not.
A better sense of when to say no.
She's the OnlyFans trial defendant.
I'm not helping.
Super loud. She wants to get out of bond, but I think there's flight risk issues in that one.
One more continuance.
Is Julie in a coffee shop? She looks like she is. What's the logo there on the wall? Did anyone see?
That one was pretty easy. I might just make sure full testing.
that it was like 2 months ago and they're still.
Yeah, a little bit, but it's also the holiday season, so everything's weird right now. Going into like Thanksgiving and stuff. It's like, yeah.
That was more of a question. I don't.
Yeah.
I don't know how long it's like. I don't know how long it takes to get to these programs.
The DV ones I know can sometimes be booked out pretty far. For substance evaluations, I think I've never seen them have to take longer. For this one, he entered SOC. These are the only two problems we see right here. So there hasn't been like a huge history of well, he hasn't done it, so technically there is non-compliance, but he's supposed to close out in October. It's told right now. Give him one more continuance, and then, like I said, at the next hearing, we gotta like move on. We got a continuance here. One more for an SOC.
And we still have jurisdiction because
non-compliance tolls it essentially.
Until they're back in compliance.
Until they're back in compliance, and then it's like, oh, no, it's up. I'm dismissed. So they're waiting
Which
for
is what necessary anyway. So
yeah. So basically, they're waiting for the court to say like you're in full compliance.
Got it.
I'm like, this, the SOC thing is. We should.
Is Judge Wilcox going to come back? I don't know. Yeah, the hearing starts at 1:30, so we've got just a few minutes before. Well, if they turn on the feed early, we might get video any minute now. But. Yeah, they're just doing their jobs, but it's interesting to hear them argue for that.
Yeah, we'd ask for it. I'm just meaning technically.
Yeah, so that's another thing. It's like, okay,
This hot mic is taking forever. You might find another court to watch in the meantime. I thought Thurston would come through for us, but they're not. Super excited to see my son. Guys, I've said that once already.
I'm glad. It's just this guy. You already filed that motion to vote. I'm going to remove it.
Should we go to Minecraft Court? See what they're up to. Let's do that.
That's fine.
You're to maintain full employment and pay the costs and supervision fees in this case. Anything else, Ms. Randallson?
Mr. Honor, there are actually 2 days jail time credit.
2? Okay.
2 days jail time credit.
All right. 2 and 2. All right, Ms. Rushing, do you understand the terms?
Yes, sir.
Okay, not that difficult, not that complicated. Just do what you're supposed to do, and you're not going to have any problems. If you don't comply, the state will file a motion to terminate your community control. If I find you violated, there's a potential of 12 months in prison. You understand that?
Yes.
All right. Anything else, Mr. Whidden?
Not from the state, Your Honor.
Your Honor, do you I apologize. Brian Waltz, 0072878. Do you typically advise them of the 2 years discretionary PRC at this time as well?
Not unless they sentence them to prison, so.
Okay, all right. Thank you, Your Honor.
Tom, is there anything else?
No, Your Honor, thank you.
All right, we're adjourned. Thank you.
All right, Marion, so you're gonna go. Kim, you want her to come up for probation right now, correct? Yes. Okay, perfect. So where you went last?
All right, that was a quick one. They adjourned quickly. Let's go back to Thurston, see if they're done. Nope, still getting dizzy. Okay, we're holding off waiting for the sheriff. The sheriff shot the judge trial, at least a hearing. This is a status hearing, an update. The case has had a lot of twists and turns, mostly the most sensational part, and what originally was thought to be the reason behind the shooting was the sheriff either finding out about or, worried that someone else was going to find out about what was going on in the courthouse, what was involving some of the deputies. I don't know what you call it. It's not pay to play. It's play to get preferred treatment plan where women who were facing revocation of bond, jail time, high fines, things like that, would get preferential treatment if they would do favors. And that had been going on and was prolific. Like, everyone in town knew about it. This was just, everyone knew that it was a bad deal that was going on. And amongst all that, and the blackmail or ideas and everything else, that then the sheriff and the judge go out to lunch sometime and are talking with each other, come back to his office and are talking with each other. He's in his office on video, and they're talking. They pass a phone around and look at the phone. The sheriff looks at the phone, gets up, pulls out a gun, and shoots the sheriff, and finishes him off. Makes sure he's good and dead. It left some questions because obviously the video is in evidence. It was there in the courthouse. The murder happened in the judge's chambers, and it was the sheriff that did the shooting. There are some mental illness issues that are being raised. There are bond questions that are being raised. Some of those will probably be addressed today in the hearing, as well as just a general status update to see how we are preparing for trial, what the status of that is, where we're at. But if this one does go to trial, there's an anticipation that some crazy, pretty wild testimony is going to come out, and a lot of people's names might be named. People that work for the county, that work for the city, that work for the police or the sheriff. And it would be a wild one. Francis Fitzgerald, I love being part of this beautiful community. RA, go get ready to pick up your son. Drive safely, enjoy your family time. A member for 18 months. I think plus a little longer. That makes you an OG. I have plenty of time. He doesn't land till 5-ish. And it only takes me 2 hours to get there. So 4 hours of driving for me this afternoon. Yeah, it does. It reminds you of the I shot the sheriff, but the sheriff shot the judge is the storyline in this one. So once that goes live, we'll bring that to you really quickly. See if we have anything else we can. Still waiting. Let's see. On 3. Gonna check some of the other courts up in Thurston. 3 is not live. Oh, 3 is live. Here we go. We have one we can jump to. Let's do this one.
Those. Oh, sorry.
Sorry, that's 20 on each case, so 40 total.
20 on each. I'll make a note on each order. If you do all those things at the end of that 24 months, then the prosecutor is going to dismiss each of those charges. Now you're waiving your rights though as part of this. So you're waiving the right to a speedy trial, and instead you're going to get a 24-month continuance like you're asking for. You're also waiving the right to have a jury trial. So if the prosecutor were to prove that you violated any of the conditions you agreed to, you would have a trial, but that would be to a judge only without a jury. And the only evidence in your trial would be the police reports that the prosecutor submits to the court. So unlike a normal trial, you wouldn't be able to testify yourself, call witnesses to testify in your defense, or present any legal defenses to the charges.
All right, we just got courtroom feed out of Kentucky for the sheriff. Commonwealth of Kentucky. I didn't know Kentucky was a commonwealth for some reason. Why did they just tell me today? I am in North Carolina, for those that are asking. Waiting for the sheriff is expected. That actually might be him that just walked in. That looked like him with the short hair and the glasses. You are a commonwealth. What does that even mean anymore? Is it just a point of distinction? Or is there like a financial difference for the members and the residents of Kentucky? Kentucky's a commonwealth. Somehow I knew that. So Massachusetts, Kentucky. Are there any others? I realize Texas is like a land unto themselves, and they have reserved the right to secede from the Union at any given time. They could just leave. You know, the rest of the 50 states can't do it. Texas can. I'm so interested in this case. Me as well. Hippie Mimi. And this is, I realize it's sensational and it's salacious and everything else, but how often do you have a sheriff shooting the judge in the judge's chambers? Okay, there's the defendant right there. The big guy in the tan, that's the sheriff. Sheriff Steins, or the former sheriff. He's now in custody. Looks like he's a little bigger now than he was before. I mean, I'm not trying to judge someone's weight, but it looks like, I don't know. Those chairs are hammered. The arms keep hitting the table, and they're all broken there. It's more common than you think to be a commonwealth. We have bourbon, horses, bluegrass, and small towns in Kentucky. You got mountains, too. Okay, Commonwealth states are. There are 7 Commonwealth states. PAVA, Kentucky, MA. What's with it's an a thing? Virginia is a Commonwealth. Nobody west of the Mississippi, though, right? Tequila Mockingbird. I think because there's so much misinformation and speculation in this case, it's probably going to take opening statements for us to start making heads or tails as to what's happened here. Virginia's a Commonwealth. What state was this? This was in Kentucky. Kentucky. Don't expect this hearing to be a lengthy one. They might address bond again and see. They've been trying to get him out on bond. Probably not going to happen. Don't think he's going to get let out. The judge probably won't make any big rulings today. Anything that he does have to decide, he'll probably take under advisement. But every bit of information we can get in this case is a little bit more helpful in figuring out what actually happened. This is just a hearing. It's just a hearing. We may get, and we do expect to get dates as to future hearings, and possibly even set the trial dates and see where we're at for that one. There are only 4 Commonwealth states according to Google machine. Denise, it's a different airport. The plane that crashed was in Statesville, and my son's flying into Raleigh-Durham. Statesville is a small airport. Raleigh-Durham's international. Not surprised there are some people in power doing bad things. We have a sheriff in the next county that's accused of selling impounded cars illegally. And guess what? The charges were dropped. Wow. Get your car towed and sold without your permission. Red Pen does cry a little bit and make a note of every misspelling in chat. Of this, I am aware. Is Raleigh-Durham also Charlotte? No. Charlotte's different. Charlotte's down on the south end, next to South Carolina. A couple hours away. Too early for defense strategy, but manslaughter in the first degree, Class B felony, carries a sentence of 10 to 20 years if it's a crime of passion or committed in the heat of the moment. And that was the speculation, because we see on the video the sheriff looking at something on his phone and showing the judge, or the judge looking at something and showing the sheriff. I'm not sure how the exchange went. And then it went straight to shooting. Yeah, thoughts and prayers with Greg and his family, who were, I believe, 5 or 6 people were on that plane. All fatalities. Did a lot of good during the hurricane, or right after it. Okay, just holding tight. We're going to stop the court hopping for a bit. This case hints of judicial misconduct, corruption, and mental breakdown. It's scary. It is. It's crazy. I'm hoping that it makes sense. Like, connect the dots. My mic is just so hot. It's just every mouth noise I make, it's picking up. That's a little bit better. Should start here in the next minute if we're on time. The sheriff just looking at the paperwork. The sheriff has a chain on his wrist, like a jewelry chain. Doesn't look to be a medical tag. Interesting. Yep, that's a stack of papers. Guess they allow him to keep a little bit of his bling in the clink. Wait for all of them to sort of snap to attention. What's with the gum? The gum in court. It's a binder clip. You can't have binder clips. It's a massive binder clip. Okay, they just clipped the binder clip on the mic mute button on the microphone to hold down mute. It's normally a toggle switch. Waiting for the prosecution, waiting for the judge. Small little courtroom. Terrible back support on their chairs. It's low tech, but it works. Yeah, if it's stupid and it works, it's not stupid. That's what the saying goes. Has the motion to move the trial ever been addressed? I can't remember. I think it would be about this point that sort of motion would be raised. It's going to be as they're approaching the date of court prior to jury selection. Okay, everyone's just kicking back, waiting for the judge to come in. May I say the light fixtures don't fit the room? Maybe if we saw the rest of the room, it would help. But the tables that the attorneys are on do seem out of place, as do the two lecterns. Seems like they were bought as an afterthought.
I was kicked back, taking it easy.
Tequila Mockingbird, welcome. Used a binder clip to hold a baggie of ice on our thermostat at work to get the heat on. We froze to death, death at that place. Oh. Oh, man. We're out to Sarasota. Let me look at the weather for this afternoon. We've got about a 90% chance of rain in Raleigh today. Might be a bumpy landing. Doubt he'll get bail. It's a high-profile case and someone died. Yeah, murder is usually not one they give you bail on. You know, if it was a manslaughter case, I can see it. But this is one where just the facts that we have, the video we have, is a lot already. It's clearly, I would say, intentional. Unless you've got some mental illness where he did not, in fact, know what he was doing. I don't know how you could argue that, nor how you could prove that in the moment. Okay, bailiffs in suits. Whoa. Bailiff comes out and says, Judge would like to see you in chambers. The other bailiff says, here, you can drink his water while he's gone. Help yourself. Bailiffs are just all leaving. You know, if enough bailiffs leave, you don't need bond. You can just get up and go. This is wild. It makes me wonder if prosecution was already back in an ex parte meeting with the judge, because defense was not present, but now defense goes back, but we haven't seen prosecution. Bailiffs in Suit should be the name of a band. I think it would be a jazz band, though. Just trying to see if he's in fact wearing shackles. I don't see anything on the ankles. Oh, might be coming back. Now the prosecutor comes back too. And we pause for station identification at this unfortunate moment. And here comes everybody. We're about to get started. a lot of nodding, like something just went down, something just happened, like a decision just occurred. Okay, here's the judge. Let's give it a listen. Should get audio here in just a second. And by should, we're going to do bad lip reading only. While we look and see if we can get an audio from anywhere else. This is the point where you fire the cameraman.
Procedurally, before we move forward, due to the nature of the case, we want to make sure it's done correctly and handled appropriately. So once that issue is addressed, we will reset a date for all pending motions. Anything else on behalf of the Commonwealth?
Will we approach your own?
Sure.
They just pushed everything off, but we didn't hear why. We'll have to wait till somebody in court tells us.
Just in regard to the Commonwealth's change of venue motion, I will take that. But I do have
Change of venue?
Supplement for the record.
Yeah.
They've already been provided to council, but I just wanted to make sure the part of the record before I lose
All right.
originals.
Anything else?
Nothing else is going on.
All right. All right. With that, court is adjourned.
That was quick. I told you it would be fast. No major decisions. The only thing we got, we're gonna have to listen to. We're gonna have to listen to the Twitterverse to see what the judge said at the beginning, because we missed all the audio. We waited all day for that. Yes, it was a short one. I told you it was a short one. The Commonwealth filed a change of venue. We're moving it. It's getting moved. It was worth waiting for, wasn't it? I just want to hear what the judge said. All right. That's it. We're done. We're done. They're punting it into January. It's probably going to be into the next year, but it sounds like the change of venue motion that the Commonwealth filed is going to be decided first before they look at anything else. As far as setting dates, obviously, for trial. I'm not seeing any updates online. I guess we're done. With that, I can get ready and go pick up my son. So that's going to end it for us today, as we are not having the podcast tonight. I do apologize due to Thomas is working his butt off doing a cattle drive, which is hard work. It's real work, and he's up at 4 o'clock in the morning. So we're not going to drag him late into the evening when he has to be up again tomorrow morning at 4 and do it all over again. So I get to go see my child who's back from college. I think he's still got a 4.0 as well. He's doing great in college. Just got offered a job in the field where he's working with a teacher doing it as a TA for that class, because he basically knows it all. So we're excited to talk to you about that and give you updates. I'm excited. I've gained access to a major electronics retailer's database, and I've done this all legally. I've requested through the retailer, and I've gained like programmer level access to their database, not to change, but to review a notice. And I've got a project for my son, and it might involve getting really good deals on a lot of things. So I might tell you about that later. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning. Tomorrow is Friday. As Thomas would say, I'd say happy Thursday. He'd say happy Friday Eve. It is Friday Eve. We'll be live again tomorrow with more court hopping as we prep for the holiday season. It's not Sweetwater. It's not Sweetwater. It's more. Think red and blue. You're yellow and blue. Yellow and blue. But that's all I'll say. All right. I'm excited about that. It's a store that does manual pricing changes, and they make mistakes. Sometimes they sell things that are very expensive for very little because they screw it up or they just want to get rid of it. And now I'm going to have access to that system. So, all right, that's neither here nor there. It's a little nerdy. You guys be good to each other. We'll see you tomorrow. Happy holidays, everyone. Bye-bye.
I was kicked back, taking it easy.